Hey guys, it's Kathy. I hope you're doing well. I've missed you. That was a long 2 days, wasn't it? Whew, man. So I got a lot done. I didn't get everything done I wanted to. I spent 18 hours at least on this one trial in the last 2 days, and I couldn't get it. I couldn't get it together. I couldn't fix it. I couldn't fix the audio. The audio was separated like 5 minutes from the actual video, and it was broken down into all these little clips, and I was trying to piece it together. And then 18 hours, I thought, you know what? I'm never going to get this. So the reason why I really wanted to get it so bad was because I put a short out, and people who saw the short said, hey, where's this full trial? Where's this full trial? Well, you know what? The full trial is gone. It's never coming back. Never. Oh man, look at this chat. I miss chat. Didn't you guys miss chat? I'm just going to look at chat for a minute because it's so pretty. So I thought today we should actually start with a little bit of Fleischer, and we're still going to end with Fleischer like we should. But I wanted to bring the one up first because it was awesome. It was so cool. In Fleischer's courtroom Thursday? Nope, he wasn't there Thursday. Wednesday, another judge popped in and annoyed me first. I will tell you why he annoyed me first, but then he fixed it. Don't worry. Then he fixed it, and then everything was good. So Judge Fleischer was working together with another judge at the same time. It was so cool. I missed you guys. Yes, another judge from Louisiana, darkest. And trust me, I tried, guys. I thought, you know what? Let's see if we can get more of this other judge. And you can't. He doesn't live stream. So if you don't live stream, you can't find the live stream. So I couldn't find his live stream. Luckily, though, while I was searching for his live stream, I found a whole bunch more live streams that I never knew was there. Thanks, guys. I missed you guys too. Like I told you in Discord, it was terrible. Last night I slept horribly. I had this dream that I went into Discord and I'm like, hey guys, I'm gonna start streaming. I'm gonna start streaming today. And then I started my stream and I had no content, nothing, no content at all. And it was so real. I woke up and I was like, oh my God, this is horrible. This is the worst thing that's ever happened. I'm glad I took those days off though, because, like family got crazy in the last couple of days. Crazy. And if I would have been, trying to get these out, that would have been a lot for me. Some guy shook my hand tonight. And I know that you guys have to have a firm handshake. I get it. You have to prove to yourselves. I get it. I understand it's, it's supposed to be a good thing to have a nice firm handshake. But pretend all women's hands are broken, because my hand is broken. And I had to sit there. I shook his hand. He squeezed and like, you can't make a face. You can't. So now my hand is throbbing. I'm going to have to do everything left-handed. Well, I know what you're saying, John. Firm but not crushing. But what you men feel is firm, a lot of ladies feel is crushing. You guys just have more muscles than us. You just do. We are more fragile. I know, Carolyn, trust me, I know. Yeah. So you know what I mean. But the thing is, my hand is broken. I just should have never. I should have been like, "Ooh, germs." That's it, guys. Today, which no one's going to get a handshake today. If anybody gets a handshake today, just go, "Ooh, germs." Okay. No, my hand was broken before he. I broke my hand like last week, and it's still healing. And he was like, "Roar." Okay, I'm going to start with Judge Fleischer. Here we go, guys. Here we go. I hope the audio is on.
Um, Good morning, Judge.
Hey, good morning.
So where are you?
Opelousas, Louisiana.
Fantastic. Good tidings. Welcome and thanks for coming.
Thank you. Where's the docket number? Judge, I believe you have one of our defendants, Daviante Mitchell, and I believe he's being held on a bench warrant. And I'm willing to recall the bench warrant, but I wanted to give him notice. We've had troubles. The bench warrant is not valid because they were not able to serve him. However, I wanted to give him notice, basically in open court or via Zoom, and then I'd be willing to recall the bench warrant at that time.
Okay, let me grab.
Okay, I don't know if you noticed, but when Judge Fleischer addressed Judge, whatever, I'm not looking at those tiny little words. He said, "Judge, hello, Judge," or whatever. And the judge replied, "Hello," which really annoyed me. It really did. How dare he? But don't worry. If he didn't already and I just missed it, he does call him Judge back. He does.
Real quick. And then where did everybody go? Okay. Our local prosecutor here stepped out to go grab all the parties and bring them in.
Sure.
Okay.
You don't take away from.
Huh?
He's actually working.
Wonderful. Let me see if I can.
Yeah, I need it. Hey, 1 minute when this is done.
He's 1 minute to calm down from Winnet or jihad this morning.
Does that mean productive otherwise?
Yeah, I think so. It works having Judge Rose set up in the back. Judge Rose set up in the front.
Yeah, this is Judge Fleischer, Code 5. We were looking for Carl.
Listen, guys, the bigger clip of Judge Fleischer from today is still is exporting right now, and I don't have my computer back yet, so it's exporting. Yeah, I'm getting there, Sarah. I'm getting there. It has. Hold on, I'm looking. It has 8 minutes left, so I can get it done in 4 minutes if I stop the stream. I can get it done in 8 minutes if I keep the stream going all choppy, which is scary because it had 7 minutes left and now it has 8. So I can't stop it. I don't want to stop the export because we need that. I'm just going to keep going. It's a little choppy for now, but it'll stop being choppy as soon as the other Judge Fleischer video stops exporting.
And his client, and we have the actual Louisiana judge online now. Everybody waiting for me. Can you reach out to Carl and find out where he is, please? Daviante Mitchell. Please. Thanks.
Yeah. Page 17.
His, I guess, clerk, court clerk or something, or maybe a lawyer or whatever.
Carl's
She
not
just
back there,
reminds
is
me of a Charlie's Angel. Hi, Charlie.
I don't know where they went. I'm looking for the counsel with defendant. I have no idea. Sorry to keep you waiting.
Oh, no problem.
Or she looks like Monica from Friends.
That's why we're trying to figure out everything now.
Oh, okay, just heads up. So when he's,
I think you reach yourself, Judge, and so they're ready.
yeah.
Sometimes Victoria and Melissa stand there beside the judge.
Have you been able to get a hold of Carl? What is his cell phone, please? Hey, Stephen, grab him. Up, Frazier. He stays with us. I called his office and tried to get his phone number, and they kept repeatedly hanging up on me. So
Is it in the courtroom?
Contempt of court.
I'm sorry to keep you waiting. I don't know where.
I have a little information. Mr. Moore just called my office to say he was in another courtroom, but that he was on his way. So,
Okay, great. So you should be here momentarily. Thank you for telling me.
yeah, no problem.
Judge needs a little flower for his
So-
buttonhole.
You mind? So what exactly are we doing now? They're going to recall the warrant.
If he does, then obviously that solves my problem, but I just have to see.
Does that mean that you're just going to file an ollie on this case, and then it's
Right. And that was,
then they'll direct him to go back to?
and that's part and parcel of the issue that I wanted to bring up, that I want to wait for time to show up regarding the attempts, but yeah, hopefully it'll be short. I would be surprised if it takes more than 2 minutes.
And I mean, I'm going to admonish him that if he ever gets popped here again, it's not going to happen.
But
He's not going to admonish.
because it's scheduled on Zoom, I want to stay, but then Carl
I don't know what home. Yeah.
Buttonhole.
Mesh, if you don't mind, I'm gonna handle something real quick while we
No problem.
again thin out the herd of lawyers piling up.
Completely understand.
But as soon as he gets here, we'll stop everything. We'll drop everything.
Oh, thank you.
Yes, come on.
And I was on there before and I couldn't hear.
No, it's Mr. Mitchell.
I'm grabbing necessities, So,
For some reason, I was thinking that he was on bond, but I guess he's not.
Yeah, Judge, I'll explain when he comes up. Or Judge, if you don't mind, I'd like to explain our position and sort of, our conditions for revoking the bond. I mean, for recalling the warrant, excuse me.
Most certainly, most certainly. Hey, Carl, what's your cell phone number?
281-802-7802.
Right. Okay. Now it's easier to get a hold of you.
I have yours. I need to text you.
I thought I had your phone number too, and I looked at it.
You wrote yours down for me.
I know that I've texted you before.
Let me text you.
All right. Good morning, Mr. Mitchell.
You want to come around?
Okay. So I don't know why the TVs aren't working, but here today we have your judge from Louisiana. Judge Mitchell, the floor is yours.
All right, for our record, this is State of Louisiana versus Deviante Mitchell, 23-01829D. For the record, the prosecutor, Ms. Katie Ryan, is present in court. His court-appointed attorney, Mr. Alfred Boudreaux, could not be here. The only issue before the court, however, is a bench warrant. Mr. Mitchell, I want to explain to you what happened. You appeared before me for a bond hearing. I gave you an ROR bond based on the reasons I said in court that day. After that, the state got the file. The state has charged you. When the state set it for arraignment, the sheriff's deputies tried to serve you 3 times at the address you gave the St. Landry Parish Sheriff's Office. They were not able to serve you. It looks like someone at that address was playing games with the sheriff's department and evading the service. So a bench warrant was issued. And now we know where you are. You're in jail in Harris County. They want me to recall this bench warrant. The only way I'm going to recall it is if you agree in court today to appear before me on June 27th for arraignment. If I recall the warrant, Mr. Moore, will he be, I don't know what's going on in Harris County, but do you think he'll be available to make himself appear? Or
Maybe I heard wrong, but did he just say five attempted murder charges? Judge, if you gave someone with 5 attempted murder charges a PR bond, that's on you. That's your bad. He didn't show up for court? Really? Maybe I heard wrong. Someone will correct me. I'm positive someone will correct me.
make himself available for court in St. Landry Parish on June 27th.
Yes, sir, Your Honor. I've spoken with his mother, and she has assured me that she will make sure that he will be in court, and he's also told me that.
Now, I'm not, I do have a prosecutor here. I have no intention of revoking his bond, even though a condition of his recognizance bond was no criminal activity. But because it happened in Harris County and we don't have access, I have no intention of that. However, he has been billed here with, I believe, attempted murder. 5 counts of attempted murder. Those charges are not dismissed. He was given an ROR bond for very specific reasons stated on the record at that bond hearing. But the state has since chosen to indict him by bill of information, and is moving forward with those charges. He has to come back to St. Landry Parish for arraignment on June 27th, 2024, 9:00 a.m. before me in the criminal court annex.
Are you familiar with the new case that he has here as well?
No, sir, not at all.
He picked up an unlawful possession of a prohibited weapon, which is a felony case. That bond is set at $50,000 now. He has not made that bond as of yet. With us here, because he's a fugitive, I have him set at no bond. If you recall the warrant, that will lift this hold that I have here in our fugitive case. He still has to make the $50,000 bond in his felony case here, though.
I figured as much, and I believe that's what Mr. Moore is perhaps trying to accomplish, was to at least lift this bond, and also our sheriff's department would have to go get him, and they're overwhelmed at the moment and all. And I'm willing to give him another chance to appear, but trust me, if he does not, he is now, if I recall the warrant, which is not valid for lack of service, he has now been served in open court, been given notice in open court. If he fails to appear on June 27th, trust me, the next warrant will not be recalled under any circumstances.
Judge, can we get a good address on Mr. Mitchell?
And a condition is I need to verify his address, and I need to know, I need a good address. What address are you living at in Alexandria, Mr. Mitchell?
4131 Phoenix Point Drive.
Oh, that's not his
4131
address.
Phoenix.
That's not his address.
Drive.
Do you have an apartment number?
It's a permanent.
Well, what's the address?
Or apartment B?
That's not his address.
What's the name of the apartments?
Phoenix Point Drive. Like when you 4131 Phoenix Point. It's called Phoenix Point.
Would your mother know which apartment number it is?
Yeah, that's how.
Does he know where he lives?
Well, he doesn't know the apartment number because it's his mother's apartment. I'll find out. What's her number?
She gonna answer.
Yeah, I'll step away.
Sure.
Well, let me just say, Judge, just to try to expedite. There were 3 attempts at service.
Okay, that was the
there, all
correct
of which
address. I
failed.
muted it.
Part of the reason he was given the ROR bond was his mother presented evidence of I guess you could say an alibi at the bond hearing, and the state was not quite prepared at that time. They didn't have the full investigative file to offer evidence to dispute the alibi. And so I gave him an ROR bond. But that was the whole issue, was that he was living there with his mother, and he would stay at home and, be a good boy while out on bond.
No luck.
Well, I spoke with her. She says that there.
Okay.
All right.
I'm sorry, Judge. I don't know what else.
That's fine. We'll note that he maintains that his address is 4130. Written notice that he has arraignment before me, June 27th, 2024,
Hi, Nace.
at the St. Landry Parish Criminal Court Annex, 9:00 a.m.
Yes, sir, I will.
Judge, and I'll say this, that you can't run forever, dude. You just can't. You gotta go back, and I'm gonna tell you, if you don't, you're old enough to know actions have consequences. You get popped here in Harris County again, you will not get another bond. They can take up to 90 days to come get you from Louisiana. Up to 90 days on a governor's warrant. You understand? You've been given a chance. Okay?
All right, for our record, I'll recall the warrant. I want the minutes to explicitly state that he's been given notice in open court of his arraignment date of June 27, 2024 at 9:00 a.m. In the criminal court annex, and that no further bench warrants will be recalled.
You know that the family's gonna post the 50,000?
They are.
Okay. Okay.
All right, thank you, Judge. I appreciate
Thank you for
it.
your time.
No problem. Thank you.
Take care.
Hey Nate, I haven't seen you for a while. I see you in my chat on my comments though, and your comments are great. I'm just going to talk for a minute because Judge Fleischer's video is killing me. It's killing me. And I'm hoping maybe if I don't play video for a minute or two, then it'll zip through. Looks like it. Like it's working. It's working. Because it went from 8 to 15 minutes because that video was playing. So it was going backwards. It was still going, just very slowly. Now it's going a little faster. Not fast enough, though. Not going fast enough, guys. I miss my computer. Like, I keep singing that Sinead O'Connor song all the time in my head. Because nothing compares to you, computer. Nothing. None of these other computers compare to you. But it's okay because I have, what do I have today? I have black onyx incense to make me feel better. A good smell. All right, it's down. It dropped down. It's going faster now. This is working. It's better to talk for a minute now than try to man, it's just not going fast enough though, guys. I know, Nays, I know. So, all right. So if you noticed on Judge Fleischer's live stream today, it was broken down into different parts because I think they were trying to fix the camera. And on one of the middle parts, there's this big head on the screen. That was IT trying to fix his camera. And they did not get it fixed. I didn't get a card, Jacques. I'm going to go look. I'm going to go look tomorrow. They can complain. Oh, true. I'm not pausing any video. That's true. But, you know, they can fast forward through this part easy. So if you're watching this later and you see the blue screen, just fast forward through it. I'm trying to make the rest of the clips better. It's just not going fast enough for me. It's just not. Everything is shut down. So before anybody asks, everything is shut down except for this live stream. I should have rebooted. I could just play the video and then fast forward through myself. It would probably take hours less time. But I don't think you guys would like that. For me, just keep fast forward. Hi, Debbie. I'm just watching chat to make sure I don't miss anything. I know I missed everything at the top. No, I did not. Washington State. I wonder which county, because Washington plays. There's a frauditor in Washington State, says Kelly. I missed the support, Llama. Carolyn, definitely. You want to know how my day was? It was terrible. I work at a bar. I work at a brewery, and sometimes people drink too much. And yeah, it's my fault. I serve them the drinks. It's completely my fault that what happened to me today happened to me today. Well, when people drink too much, sometimes the alcohol giveth back. And the guy made it to the bathroom, and there's a urinal, and there's a toilet, and there's a trash can. And the closest thing is the trash can. And the biggest thing is the toilet. No, he didn't choose either of those things. No. The alcohol gaveth back into the urinal. So yeah, that's how glamorous my night was. I was up to my elbows in latex gloves, trying not to make a bigger mess. Oh man, yeah. My tables have fun. They do have fun. That's a fact. Because why would you go to a restaurant? Like, you can cook at home. You can cook at home, but when you go to a restaurant, you want to go out and you want to have a good time. You want to forget about everything. You don't want to worry about anything, you know. So yeah, my tables forget about everything when they sit in my section. I don't even know who it was because I don't feel like anybody. See, it's not like a bar where people are downing shots. It's more like a restaurant. It's a brewery. You know, people come and enjoy this stupidly expensive beer. I can't imagine paying all of that for a beer. I just never would. Never. Oh, jeez. Guys, it's... David Fleischer. You are going. And the thing is, this guy, it's exporting, and I can see what part it's at. I'm pretty sure this guy's a good one, so you want to see him. I'm pretty sure he was entertaining. No, Jacques. You don't understand, Jacques. You don't have to request my section because I'm everywhere. I go to every single table repeatedly. Sometimes we do have sections, and the other servers take a section and they stay there, but not me. Not me. No way, man. I am at every single table. Unless I don't like you. And then I don't go to you at all. I don't care. No one can make me go to you if I don't like you because, you know, I get paid, $2 something an hour. So fire me. If you're going to be a jerk to me, you don't deserve me. You don't get me. This one guy, he's a regular. He comes in all of the time, literally all of the time. And he left me a $1 tip one night. It was him and his girlfriend or a lady friend. I don't know. Maybe it was his daughter. I don't know. It was a lady. And he got one drink, one beer. And then she asked for a water. I got her water. She says, well, no, can I have lemon? Fine. I went and got her lemon. She drank that water. Can I have another water? Can I have another lemon? Yes. Here you go. He only got one beer. So he left me $1. And I haven't spoken to him since. He comes in, he sits down, I walk away. I walk by him. Other people just get him because I'm not. Why would I? I mean, he doesn't pay me. If you're not going to tip your server, they're not going to serve you. So he didn't tip his server. I'm not serving him. He has tipped okay since then, but no, it's too late. You lost. You can have the other servers. Good luck with that. They don't serve like I serve. You should have been nicer to me. And then yesterday, Thursday night, I got off work at 6:00 because it was dead. I made $18. I got off work at 6:00, but I knew my boys were coming in. It's a whole squash group. They play squash. Don't ask me what that is. I think it's like racquetball, but it's probably more like lacrosse. I have no idea. I've never played squash. They come in and not every Thursday, but on Thursdays, because that's when they play squash. I wanted to pull that up, Chuck. Hold on. So yesterday I got cut at 6 and I stayed there and quality control tested the beverages until they got there. And then even though I wasn't on the clock anymore, since they're my boys and they come to see me, I got up and I did their whole table. It's a big group of them. And then the other server got the tips. I didn't care because those are my boys and they tip well and, they deserve to get service when they get there. Let's see. Jock, I'm going to look right now. I'm looking on my phone because if I touch my computer, not that I'm counting or anything, but 18 days. I like that other countdown better where it gave me the minutes and the hours and everything. But anyway. Oh, yeah. 17 days, 22 hours, 37 minutes, and 45 seconds until I can reapply for monetization, which reminds me, and I know no one's listening now because they are fast forwarding through this part, which is a good thing. I'm removing some videos before then. So if you want to see some videos that, I already did remove some of them, but well, like the child, the mother who shot the child, you don't have to watch that one. But Mish, you are special. Even your mommy said you were special. I hope. Kelly, they do. Washington trials, some of them. Washington County, some of them live stream. So we might be able to get that frauditor. I don't know. That's a Kelly. Oh, I wish I could touch my computer right now. I hate when I want to look something up and I can't touch my computer. I wonder if Washington State has other judges that are not on YouTube. That people haven't seen yet because they're not on. Well, yeah, I know, but they're going to, Kelly. Three minutes, guys. It says 3 minutes. Can we just talk for 3 more minutes? Which court case, Lori? If you say the Australian one, good luck. I missed the first part because I was looking at something else. But which court case? I'm trying to think if I left any half court cases half shown on my channel. I don't think I did. Okay, you're right. But Darkest Night, what if? What if there are other judges, just like the other states, that have courts live streaming, but they're not on YouTube, so nobody sees them? And the frauditor goes there. Then I'm needed. I'm needed for this job. With llamas. Oh, kitty. I would give you a cat distraction, but believe it or not, they don't come to me when I call them. Well, I'm going to mute because you're going to get annoyed if I call my Agara. She comes to me every time I call if I do this. Unless she's outside, which she is. Maybe she'll bring me another bird today. Maybe she'll bring me a squirrel. Maybe she'll bring me a mouse. I don't even know how there's any wildlife anywhere near my house anymore. I just don't get it. Just the one. There's only one cat that will come if I whistle. If I whistle, oh, and if I laugh, she hates it when I laugh. Hi, PJ. She does not approve of me laughing ever. So sometimes when I'm making these streams and you guys are making me laugh, just know that you're really ticking my cat off. 1 minute, 45 seconds, which is a lie, but sounds good. I have, yeah, that's about what happened here. I thought I'd just finish getting all my girl cats fixed. I know the boys have to be fixed too. I'm working on it. It's expensive, okay? And then I just looked at one of my kittens. It really is a girl. I thought they were all boys, and one of them is a girl. So now I have to go get her fixed. She's not old enough. Lightfoot, love. I haven't seen you in so long. I hope you're good. Thank you for coming. Now if only Cloud will show up. And May, remember May? May hasn't been on in a while. May, if you're on replay crew, we miss you. But don't lose sleep to join a live. 35 seconds remaining. Yeah, no one's going to like this video, Kelly. There ain't no videos. There ain't no videos playing. You got to earn likes. You don't just get likes. This isn't a participation. This is real life. Let's see if 35 seconds have passed. 15 seconds. This guy better be worth it. Let me tell you. This Judge Fleischer dude better be worth it. He is, isn't he? Oh, no. Hold on, guys. My computer went blank. Okay. I see that my camera's off, but I'm not going to worry about that for 1 second because the video is finally done exporting, so I can move on to my next video. It's the final countdown. Okay. This one. All right. Every time you hear Mr. Bauer, do a shot and stay away from my urinals. Do a shot and then stay away from my freaking urinals. Here we go. Oh, come on. Just play. There we go.
And I can't hear. Do we have Christopher Bowers?
Yes, Your Honor, we're bringing him in right now.
Okay.
Why is it choppy? It's over. Whatever.
So, are you Mr. Bowers?
Yes, Your Honor.
Okay. So, Mr. Bowers is appearing by WebEx from the jail. This is 24M 408, if I didn't say that already. Mr. Bowers, did you see and understand the video advisement of your rights before today's hearing?
Yes, Your Honor.
Okay. Would you like to be represented by the public defender at today's hearing?
Yes, Your Honor.
I'll appoint the public defender. Ms. Lyon has released 2 further advisements. Would Mr. Bowers waive further advisement?
He would, Your Honor.
So the next issue, Mr. Bowers, is I do need to issue a protection order. Is this a basic protection order, Mr. Bowers?
Yes, sir.
Okay. Mr. Bowers, you weren't in my field of vision when I gave this advisement before. I'll just go ahead and give you all of it. There is going to be a protection order that must issue because you can be charged with a criminal offense. It will continue until this case is completed. Nobody can modify the terms other than the court. And if you violate it, you could be prosecuted for contempt of court or violation of protection order terms. In either of those events, you could be subject to a fine, jail, or both. In your case, it'll simply read that you should not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. Also, I'm going to order that compliance with the protection order's terms will be a term of bond. And we are also going to give you a copy for your signature. Your signature is not an admission of wrongdoing. It's an acknowledgement that you understand the terms of the protection. So, Mr. Bowers, as it relates to the protection order, do you understand everything I advised you?
Absolutely not. Nope.
Yes,
Can you say that again?
I do. Yes, I do. I understand.
I understand. Okay, I heard that. Thank you. Okay, next we can deal with the issue of bonds. Mr. Kraus, any argument?
No, Your Honor, based on the nature of the charges in this case, that the 16-4-13.
Okay, Ms. Lyon, based on that, you think?
Unless the court is inclined to grant that, then I don't have the issue.
Okay. Based on the nature of the charges, they're both petty offenses, and I did read the affidavit. It's familiar with the facts. It'll be a $150 PR bond. I think that actually was indicated on the affidavit. So, sorry, $100 PR bond. Not $150, $100 PR bond. I'll go ahead and set it accordingly. So, Mr. Bowers, you are going to be released on your promise to appear at the next hearings. Are you going to want to be represented by the public defender after you get out of custody? Mr. Bowers, you're looking down now. I don't know if you're following me. Not getting a response. Can the deputies help me out? Is he hearing me or is he?
Bowers, are you able to hear me? Sure, I can hear him. Okay, he was asking.
Okay, so I'm asking you, I'm telling you, one, you're going to be released on a $100 PR bond. The additional term will be comply with the protection order. You understand that?
Yes, sir.
Okay. When you get out, are you going to want to be represented by the public defender in the future?
Bowers.
Mr. Bowers, that's another question for you. Are you going to want the public defender to represent you throughout your case?
Drink up, drink up, drink up, drink up.
Okay, Mr. Bowers, you're not responding to me.
Yes, sir.
If you do not understand the question, that's okay. Just let me know and I'll rephrase it.
He's trying to get me drunk, Judge. Drunk?
You don't
Judge?
understand?
I don't understand.
Okay. So you're going to get out of jail today. Do you understand that?
No.
Okay. Well, what that means is in about an hour, they're going to let you go. Do you understand that?
I don't understand. He's gonna let me go. I got nothing, man. I can't let myself go.
I didn't understand that response. Can you say that again, Mr. Bowers?
I agree.
Okay. So when you get out, are you going to want an attorney to represent you?
Yes, sir.
Say that again.
Yes, sir.
Again, I can't understand that. I know he responded, but it appears to me that Mr. Bowers is having a difficult time at this point in the hearing staying focused.
Yes, sir.
possibly awake. So one more time, do you want the public defender to continue to represent you?
Yes, sir.
Okay, I saw an affirmative head nod and a yes, sir. But Mr. Bowers, you're going to have to do something. When you get out, you have to fill out an application for the public defender in this case. Let me ask, does he have any other cases?
No, he does have other cases now. He's not represented in them.
So if you want an attorney, you'll need to get an application from the jail. Did the jail deputy give him a copy?
Yeah, Your Honor, we'll give him a copy.
Okay. And you'll need to fill that out and take that over to the public defender's office across from Jimmer's, a barbecue. Do you understand?
No,
No?
no. What do I put on the application?
You'll put this case number, and I don't, could the deputy put this case number on it? That would be 24M408.
Yeah, Your Honor, not a problem.
Okay. And then there's going to be some questions about how much money you make or how much money you have.
Anybody want to
If you
take
have
a guess?
job. You just need to fill that out and take it to the public defender's office. But listen to me carefully. If you have difficulty with that, you can also go to the public defender's office and they can help you with that application. Do you understand? Do you understand?
I do. Yes, not really, I don't. But I think I might, you know. Yes, I understand.
Okay. Again, if you have more questions, you can call the public defender's office. Ms. Lyon, could you, I should have this memorized, but I don't. Could you give the public defender's number, and maybe the deputy could also write their number on the application?
I can. 970-249-4791. And then to speak with the administrators, it's extension 0. So 970-249-4791, extension 0.
Okay. Next, Ms. Lyon, do you know are the other cases? I didn't see other cases before just you articulating it. Do we have a date when those other cases are coming back? Oh, they're all pro se. Okay. Lastly, Mr. Bowers, please listen. I'm going to set your next court date in this case for July 2nd, 2024 at 10 o'clock in the morning. Could the deputy also put that on the application?
Yeah, not a problem, Your Honor.
Thank you. So do you understand you have to come back, Mr. Bowers?
Yes, Your Honor.
Okay.
I really do.
Okay.
I do.
Thank you. That's going to conclude this hearing today. Anything else from Mr. Krause or Ms. Lyon?
No, thank you.
Okay, thank you. You can step back. Let's see here. Let's call Abraham Durante.
Okay, that was Colorado. So the first one, oh, never mind. So I'm going to take 2 seconds and fix this choppiness real quick. But you have to talk amongst yourselves for, at least 82 seconds. 82 seconds, and it'll be all better. I hope the stream doesn't end. It shouldn't end because I'm still here. The last time it ended, and then I had to restart another stream. And then for the next 3 streams, Fozzie said, Kathy's going to do 2 streams today. Remember, Fozzie? Remember that? Some twins are evil. I can't think of any off the top of my head, though. I just tried. Oh, toast with raspberry jam. Yeah, that's why all this is happening. All this is happening is because I took 2 days off and got out of my groove. Darkest Night, thank you so much, though, for the donation to the computer repair fund. I mean, you covered my butt, and in a couple days, I'm going to get my computer back. I bet you 82 seconds is already gone, and I lied. Come on, little Dell, you can do it.
Okay.
Sir in the booth, Mr. Winnet, is it?
Yes.
Let's do the Winnet's matter. All right, State versus Adam Winnet's under warrant 2024-336-1712. Counsel, your appearances.
Brooke Harley for the state. Your Honor, Kim Curtis on behalf of Mr. Adam Winnet.
All right, the state has filed a motion for pretrial detention. First, Ms. Curtis, your client has had his first appearance. Do you waive any further review of his rights or charges?
I do, Your Honor. I need to know, did the state file a motion to revoke, to detain on Winnet?
Yes, they did.
I'm just saying that Winnet's is working as hard as my computer is right now. And I'm screaming at my computer like the judge is about to scream at Winnet's. And actually, no, it's more, I think, Curtis that screams at Winnet's the most. But everybody in the jail takes turns screaming at Winnets right now.
Okay.
All right, so a motion for pretrial
Mr.
detention
Winnet,
was.
he just left the booth, Your Honor. Come
Mr.
back.
Winnet, you gotta stay where you are, sir. We're doing a hearing and it's about you, so you need to hear what's going on, all right? So hang tight until I tell you can leave, all right?
Yes, sir.
All right, thank you, sir. So in that motion for detention, the state file, they cite the nature
Your
of the
Honor,
charge. Mr. Winnets. Mr. Winnets. All right, please now left and close the door.
Judge, do you want me to block myself and call over there and see if maybe they can help just get him to get in there and stay?
Here he comes.
Yeah, please.
Can you have Mr. Winnets come back to the booth? Tell the officer he needs to stay.
They're not gonna have
Come back. Yes, sir. You have to make him stay. That's what she said. He's coming back.
Thanks.
Yes, sir.
maybe.
You're welcome.
Could be. Could be.
Thank you, Your Honor.
Yes, Mr. Winnets, do you understand, sir, that I'm asking you to stay in the booth until we're done? Do you understand that?
No, he does
Yes,
not.
sir.
Can you hear me okay?
Yes.
All right, so stay where you are, sir, so that we can finish this. Don't walk out until I say it's okay, all right? Okay, he shook his head yes. So there's the domestic violence nature of the charges, and the state also says it defends a risk of failing to appear, a risk of danger to another person in the community, or a risk of obstruction. Under the grounds cited in the state's motion, detention would be authorized under 2A 162, 19A 6 and 7. Does the state continue under those same grounds, or do they seek detention on any additional grounds?
The state is continuing on those same grounds, Your Honor.
All right, defendant has a right to be present at a hearing related to his release or detention. He has the right to counsel. Ms. Curtis is present in the virtual courtroom to represent his interests. He has the right to testify, present witnesses, cross-examine witnesses, and proper information in support of his position. He has the right to discovery. It's a limited right that's outlined by court rule and case law. A detention hearing is not a discovery tool, nor is it an opportunity to launch into a generalized attack of the charges he faces. If he chooses to testify today, he'd be under oath. It can't be used at trial against him except for impeachment purposes. If he is released after testifying, testimony can be used at proceedings related to any failures to appear, proceedings related to any offenses committed while released, or proceedings related to any violations of release conditions. If he testifies falsely, he could be charged with perjury, and today's testimony could be used against him at trial. Ms. Curtis, what's the defense's position regarding probable cause?
Your Honor, we will stipulate the probable cause.
Defense concedes probable cause for the purpose of this hearing only. They reserve the right to challenge the state's case in all future proceedings. Defendant enjoys a rebuttable presumption in favor of release. To rebut that presumption, the state bears the burden to show by clear and convincing evidence that there's no condition or combination of conditions that will assure his appearance, protect the safety of another person in the community, or assure defendant will not obstruct the
Mr.
administration of justice.
Mr. Winnet, turn around, come back. Sorry, Your Honor. Stay still.
No. Mr. Winnets, again, sir, I've asked you to stay. You can't leave until I tell you, all right?
Yes, sir.
All right, so just stay put.
All you people leaving because of my computer issues, stay. Stay put. They're all fixed now. Look, it's smooth.
Don't try to walk out.
Don't
All right,
walk
Ms.
out.
Farley, it's your motion. I'll hear you.
Thank you, Your Honor. The defendant has scored a 3 for failure to appear and a 3 for new criminal activity. Level 1 release was recommended. He does have pending charges for possession of CDS, contempt, criminal mischief, and criminal trespass. He has 2 prior disorderly person convictions and 1 prior indictable conviction for assault and 1 prior failure to appear from 2020, and he does have an active TRO against him. Your Honor, in speaking with Assistant Prosecutor Mike Meston, who handled the detention hearings last week, there is a concern here from the victim with the defendant's mental health, his substance abuse issues, and if he has a stable living situation to return to. The victim does fear the defendant and stated to her—
Mr. Winnet, sorry, Ms. Farley.
Oh, that's
Mr.
okay.
Winnet. Your Honor,
Bye, Mr. Winnet.
All right, close the door behind you, Mr. Winnet. All right?
I mean, if you guys would stop talking so damn much,
All right,
you
it's
would pay
good. It's
attention.
closed. Now, Mr. Winnet, I did not tell you you could leave, so you have to stay. Don't turn around and walk away. Keep looking at the monitor until I tell you you can leave, all right? All right. Mr. Carly?
Thank you. So I believe I left off, the victim, told our victim witness that she does fear the defendant and that she had to call the police at least 8 times in 4 days before the defendant was taken into custody, and that he has threatened her before, and she worries what will happen if he is released. With that, the state does have concerns for the safety of the victim, Your Honor, and with that, we do request that he remain detained.
Ms. Curtis?
thank you, Your Honor. Your Honor, as Ms. Harley indicated, the recommendation release was level 1. I am asking that Mr. Winnet be released. Clearly, there are some mental health issues. My understanding, my investigators were able to vet out a potential Mr. Winnet.
You're not done, bro. You gotta stay here until it's done. Guys, you guys are talking too much for him.
Your Honor, clearly there are some mental health issues here. He's on a significant amount without disclosing the same psychotropic medication. I'm not sure if he's receiving the medication in jail. Additionally, they were able to vet out an address with his daughter, which is Alicia Blaine, and Christopher Williams, who are located in Salem, New Jersey, where he can reside with. As it relates to this present offense, it appears that another daughter, I believe the allegations are that there is a restraining order.
Mr. Winnet, Mr. Winnet, turn around and come back.
The restraining order.
Mr. Winnet, why do you keep leaving, Mr. Winnet? I told you you have to stay. Why do you keep leaving?
Why?
Turn around, sir. Turn around and stay here.
Turn around. I'm not done with it yet. Would you like me to stand here with him, sir?
Just behind the door, please. You can close the door. Thank you. All right, Mr. Curtis.
Guess who does not stay behind the door? Guess. Hi, Colin.
I'm sorry, Your Honor. It appears that there's a restraining order with this particular daughter. Mr. Winnet is homeless or was homeless. Apparently, Mr. Winnet believed that there's been prior altercations with this daughter. He believes that this daughter has been taking his money and hasn't been taking care of him. He doesn't have anywhere to live. Basically, he sought refuge on her porch. He didn't threaten her or anything. She came out, and my understanding is that she discovered him sleeping on her porch. He needed a place to stay. Our system navigator, if he's released, Mr. Kyle Beating is willing to assist Mr. Winnet in following through on some mental health treatment. We were trying to come to that conclusion yesterday, but he is diagnosed with bipolar, Your Honor, and amongst a few other things. And he receives Social Security in an amount of $974 per month, but he contends that his money has been disappearing. He acknowledges he does have some other issues, but we believe that if he could be released to this address in the care of his daughter, Miss Alicia Blaine, in Salem, New Jersey on East Broadway, she can assist and maybe help stabilizing Mr. Winnet. It's the firm belief that he needs to re-engage in his mental health treatment to become more stabilized, Your Honor. Mr. Winnet.
All right.
We're not done. We're not done. We needed you to stay behind the door.
One job, sir. Stay behind the door. I love the sound of his shoes.
All right, Ms. Curtis, what's the address on Broadway?
Your Honor, the address is
Okay. All right, Ms. Harley, anything else?
No, Your Honor, thank you.
All right, I'm going to release him on level 1. I'll set the following conditions. I believe, given the defendant's limited contact with the criminal justice
Your
system.
Honor, I'm sorry.
Not done yet.
Not done
All right, release on level 1 with the following conditions. He shall not commit any federal, state, or local offenses while on release. He's to avoid all contact with the victim. Ms. Harley, can you get me those initials, please?
Yes, Your Honor, they are A as in apple and B as in boy.
It's not Alicia Blaine, is it? Sir.
Wait.
We're not done with him, ma'am.
Okay, do you want me to
Not
send
done.
it down?
I need him
So
back in
states-
here.
Okay. Winnet, you gotta stay in here until he's done.
I think we assume there are more guards in the prison than we think there are. I don't think there is a guard that could just stand by this door.
Are you having a problem hearing him, or you gotta stay in there until he's done?
All right,
Your
he
Honor,
used to have no time. Yes.
I just want to make sure. Yeah, no, I believe that's the victim because according to the report, it says here, the defendant, I observed the defendant to be in front of the steps of 220 East Broad Street, Apartment C, where he was banned from being. So apparently that is the alleged victim. So clearly he cannot return back to that address. That being said, Mr. Winnet would have to go to a shelter.
He's going.
All right, look, he just walked out. I'm going to ask your counsel to see 3 days and see whether you can come up with another place he can go.
Okay.
Right? Because if we just put him out on the street, I don't know where he's going to wander to if I can't keep him in this room.
I understand, Your Honor. I completely. I have no objection to that, Your Honor.
All right, let's do that. We're going to move this 3 days.
Kelly, I hope you don't mind, but I offered them your address for him. So nice.
And we'll come back. That'll be, let's see, the 14th. That'll be the 18th. All right.
Yes.
We'll see what we can do then.
Thank you, Your Honor.
All right. Thank you.
Am I to come in now?
Yeah. Go in.
Your Honor, does that conclude?
Are you going to stay?
I think it does.
Permission to be to go.
Yeah. Thanks, counsel.
Thank you.
Just leave.
Thank you, everyone.
Everybody
See you this
just leave.
afternoon.
See you then. Judge, I'm unmuting booth 3.
All right. Shh. We don't want these guys. They're boring. Oh, man. I'm drunk now. That's a lot of shots. Okay, I didn't take any shots, but because there's a freaking camera on me the whole time. Okay. All right. Now we're going to go to We're gonna go to New Jersey, guys. We're gonna go to New Jersey. And this judge, he likes arguing with defenders. It's really good.
All of the above reasons, Your Honor, the state would submit that the weight of the evidence favors detention in this instance, and the state requests that the court grant the order for detention. Thank you, Your Honor.
Ms. Cox.
Judge, the failures to appear sure are older than 2 years old. They're 9 years old. I think that's a huge difference.
Carolyn, we're in Jersey, but that's clearly Wisconsin.
Than just saying they're more than 2 years old. 9 years can be a lifetime in a young person's life. A lot of changing can happen. Obviously, she is charged with 2 separate shopliftings here, one in Bergen County. While that was pending, she's now charged with this shoplifting here. The only potential defense I think I could articulate to Your Honor with regard to committing a shoplifting while having a pending shoplifting is that when I look at e-courts, the only action that was taken on that Bergen County case, it appears, was the indictment being filed. So they issued it on a summons. I don't see any official court notices sent to her from Bergen County for that shoplifting. I do see a notice or a substitution of counsel or a notice of counsel on her behalf after the indictment was filed. So the timing of it, I think, tends to show that it may be high. In fact, she did, when I had the consultation, she said she didn't know that she had had that Bergen County shoplifting on the dates that are in question here. Obviously, she knows.
The PSA indicates she was arrested in March. She didn't know she was arrested in March?
She was arrested in March, I think, on this case. So, no, that's
on the Bergen matter. Am I misreading that? Let me see.
I don't know.
No, it shows an arrest date of 3/12, or no, yes, 3/12 of 24, arrested in Bergen County on that Bergen County promise gavel number 24-28302. So she and a co-defendant apparently were arrested in Bergen County on that charge.
Judge, if that's what it says, I'll have to go with that. All I see in e-courts, as you know, is what you see as well. I know she's raising her hand, but I'm just going to ask her to let me argue this for her. Judge, so I guess what I'll say is it's a shoplifting. You know, I know that you know, the state's just indicated CVS is a victim, and sure.
Oh boy, she just said the wrong thing to the wrong judge, guys. Here we go.
I guess.
Oh, no. So it's clear, Ms. Cox. I understand that you're making an argument. I'm the victim. Every time I go to CVS, I pay more because people constantly shoplift to the point that it's now driving CVS out of certain neighborhoods so that nobody there has access to the prescription drugs they need. And I believe, if you pay attention to the news, the scourge of shoplifting at many of these businesses is causing deserts in certain neighborhoods where they're not able to buy basic goods and services because nobody wants to do business in those neighborhoods in which shoplifting has become such a plague. So while I understand, oh, poo-poo, it's just the shoplifting, no, the consequences are becoming pervasive in some communities. And certainly in Union County, we don't want that to become the norm. So
I won't belabor the point. I won't belabor the point, Judge, but I will say this. I've read a very persuasive New York Times article with regard to the recent lobbying by large corporations, including CVS, that overinflate the losses that they suffer with regard to shoplifting, and that investigative journalism is quite interesting, and I can forward it to you if Your Honor wants to take the time to read it. In any regard,
I would be interested as an aside.
Okay. I would say that she's a single mother, a single 35-year-old mother of two. She has a 13-year-old daughter and a 19-year-old son. Both of those children are graduating from the same area. I think her son is graduating from University High School, I think she called it, and then her daughter is graduating from the 8th grade on June 21st. She is their sole provider. Her mother, their grandmother, is right now, since her incarceration, staying with them at the apartment that Ms. Tashonda Walker resides with and pays for in, come on, Michelle, in Rahway, 1755 Winslow Lane in Rahway. Ms. Walker has been working full-time as a home health aide for the last 2 years. So she is gainfully employed. She has some type of specialized, I certainly couldn't be a home health aide. And I really just think that if there is a provision that requires no return to the scene.
I think kleptomaniacs is a mental disease, but being a thief is not.
As the state is requesting a return to the EBS Clark location, that any danger to any victims, obviously, you know, if we're talking about victims in the more amorphous sense, she can shoplift anywhere. Anybody can shoplift anywhere. I understand that. But in that sense, I don't think that it's, I don't think the court should weigh that factor as heavy when it comes to danger to any potential victims, Your Honor.
At least she's staying in the booth.
I think that what's more important is the danger to her children, her daughter and her son. And even though I don't like arguments using children as a reason to get parents out, it is true that a daughter at the age of 13, I've been one, really, really needs their mother. And she's graduating from 8th grade. She's going to miss that. She's going to miss her son's high school graduation. I think that the court should, in this type of a case, I really cannot see why detention is warranted for Ms. Walker. If she picks up another shoplifting, there is no argument. I will promise this court, you see her in here again with the shoplifting, you can look me straight in my face and say, I don't want to hear anything out of you.
Is it the public defender's office in Union County's norm that should she, I'm certain she won't, but should she pick up another charge, are you going to be the attorney automatically?
I'll make sure I will, not automatically, Judge, but I'll make sure. And if I'm not, you can look Mr. Kane in the face and say, no, I want Michelle Cox.
Okay.
Yeah, Judge, other than that,
Okay.
we're asking you to deny the state's motion.
Very well. The court has reviewed the complaint, the PSA, the plea, the defendant's criminal case history, the papers filed in support of pretrial detention. I've heard the arguments of counsel. The PSA in this offense indicates a score of 4 out of 6 for failure to appear, 4 out of 6 for new criminal activity. There is no new violent criminal activity flag, and the recommendation of pretrial services is to release on level 2 monitoring. The defendant is 35 years of age. This offense does not involve any allegation of violence. She had one pending shoplifting charge out of Bergen County, 4th degree. She has 2 prior disorderly persons convictions. They are 2 DP hinderings from 2011 and 2009. They are very substantially older. She has 2 prior indictable convictions, shoplifting 3rd degree, eluding 2nd degree. That gives the court some pause. They are from 2018. None of her convictions involve crimes of violence, just because it's my personal pet peeve. The eluding, one of the elements there is that she created a risk of death or serious bodily injury to someone. I believe the decision-making framework is flawed in not classifying this as a violent crime, but it doesn't. Nonetheless, she has no failures to appear within the past 2 years. As both counsel have argued, she has 8 failures to appear that are greater than 2 years old. The state points to the significant number of failures to appear, while the defense points to their being over a decade old. The defendant has never been incarcerated for a period of 14 days or more. The affidavit of probable cause states that on 4/13, the CVS store manager saw the defendant enter the store and take items from shelves, place them in a personal shopping bag, and walk out without paying. On 4/17, the same store manager saw the same defendant enter the store and again take some items. The surveillance footage was obtained, and the surveillance video was then compared to surveillance video from Paramus PD, where she was identified as being Miss Walker. The court considered the matter pursuant to the factors set forth under NJSA 2A16220. The defendant is now charged with shoplifting third degree. The weight of the evidence at this juncture appears very strong. There's the surveillance video and the written statements of the store manager. The defendant's history and characteristics are considered by the court. She's 25 years old. She has this pending shoplifting charge, and she does have a prior criminal record, indicating to the court that probationary treatment did not serve as a sufficient deterrent to her future criminal conduct. The court therefore does find that she poses a danger to the victim or the community in that she continues to commit new offenses while those prior charges were pending, and despite previously having probationary treatment. The court finds that she does not pose a risk of obstructing in the sense that she's likely to threaten or coerce or cajole anyone into not going forward.
No cajoling, guys.
However, I do find she is a risk of failing to appear. Of particular note to the court is that she does not have any failures to appear regarding that Bergen County charge. So it appears that she is currently addressing her criminal matters in the appropriate way by staying in touch with her attorney, by saying and by appearing in court when required. And so therefore, I am going to diminish the weight of her 8 failures to appear, as they are indeed quite old. And regarding her more recent charges, both the 2018 charges and the present charges, she seems to have made her court appearances when required. The court has given consideration to the PSA recommendation of releasing on level 2. The defendant is a 4 of 6 for failure to appear and a 4 of 6 for new criminal activity. There is no allegation of violence in these charges, and therefore the court finds the PSA recommendation is appropriate. Therefore, the court finds that in weighing all of the factors, the state has failed to overcome the presumption of release by clear and convincing evidence. The defendant will be released on level 2 monitoring. I am going to grant the state's request that the defendant is to have no contact with the victims and not to return to that CVS.
Well, there you go. So she gets to go. She gets to go. Okay, remember, this is Jersey, so there's no bonds. There's no bail in Jersey. It's you either get detained or you get out with conditions. So she's on level 2. Once a month, she has to call in. Once a month, she has to show up to her probation officer at their day and time of choosing. No violations, blah, blah, blah. All right, same judge, but a different public defender. Same attitude from the judge, though. I think maybe a little bit more harsh with this one. She's coming. They're both coming.
And Ms. Cox, send me the
Looking for it right now.
the Times article.
Yeah.
It's a pretty courtroom, but he's not in it. All right.
Proceed with statement. Lamont. Good morning, sir. What is your name?
Lamont Dawson.
Thank you, Your Honor. We are ready to proceed with statement. Lamont Dawson.
Good morning, everyone. We are here on State versus Lamont Dawson, who is charged on a number of complaints. Warrant 2020-6 or 367, 2004. Warrant 2020-460-2004. Warrant 2019-3485, 2004, and warrant 2020-2523-2004. May I have the appearances of counsel, please?
Michael Marcus on behalf of.
Mike Bowden on behalf of Mr. Deshawn.
Good morning, Ms. Bowden. You represent, have you received the state's initial discovery?
I have, Your Honor. I believe there was a video that was sent that I initially didn't have permission to view, but I'm still prepared to proceed without viewing it.
Okay. For purposes of today's hearing, you'll stipulate to probable cause.
Yes, Your Honor.
Mr. Marcus, it's your motion. You may begin.
Thank you, Your Honor. Your Honor, as you indicated, there are 4 complaints involved here. Just for purposes of the record, discovery was sent, including the video of the council investigative report of Officer Contreras dated June 10 of 24. The complaints for all 4 matters were sent. A report of Officer Mosley dated November 25, November 25 of 2019. CCH defendant, report of Officer Valdez dated 11/26/19. Report of Officer Carvalho dated February 6, 2020. Statement of the victim dated February 6, 2020. In addition, Your Honor, as I said, all the complaints, the CCH, I believe there was some other miscellaneous material sent, as well as additional discovery that was sent to the court and to counsel yesterday, including a report of Officer Molina, dated February 15, 2020. A report of Officer Mosley, November 11, 2020. And there is an additional statement dated November 11, 2020 of the victim, Your Honor. So for purposes of the PSA refers to 11 current charges on those 4 separate complaints, Your Honor. Chronologically, the first complaint dated November 25th of 2019 has a charge, 3 charges: terroristic threats, 3rd degree, harassment, petty disorderly person, and criminal coercion in the 4th degree. The second chronological complaint is the one dated February 6th of 2020, criminal mischief, disorderly persons, harassment, petty disorderly persons complaint. The third complaint would be the February 15, 2020 complaint, which has unlawful possession of a weapon offense, second degree, quite serious, a graves offense, Your Honor, as well as terroristic threats, third degree, harassment, petty disorderly persons, and a second degree possession of a weapon for unlawful purpose. Second degree, that's the February 15, 2020. And then lastly, the complaint dated November 11 of 2020 has two charges: contempt of a domestic violence order, disorderly persons offense, and harassment, petty disorderly persons offense. Honor, the specifics are contained in the affidavit of probable cause for each of these complaints, and the accompanying police reports. I don't know that I need to refer to each one separately, but with respect to, since, the probable cause has been stipulated to, with respect to the February 15, 2020 complaint, Your Honor, I would call the court's attention to that one, in that there are probably the most serious offenses involved there. It is alleged that the defendant pointed a handgun at the victim through her window for that complaint, Your Honor, and thus the charges that resulted in the unlawful possession of a weapon and possession of a weapon for unlawful purpose were issued in that particular complaint. So, as evidenced by the fact that there's 4 complaints over 4 dates, going back from 2019 through November of 2020, there's just been a series of incidents involving the defendant and this particular victim, which are alleged. I know that there was an incident where threats were made to kill the victim and/or cause harm to her and to her family and to people that she knows, resulting in terroristic threat charges, as well as criminal mischief charges involving destruction of property and glasses that shattered, and it's alleged that there was some injury caused to the victim as a result of the criminal mischief allegedly committed by the defendant. In that particular matter, I think that that's complaint 367, and then various allegations involving harassment and phone calls and harassing statements made during the course of the complaint for February of 2020, February 15th.
Mr. Prosecutor, stop. It's enough.
February 6th, 2020, harassment again, November 25 of 2019, as well as the last chronological complaint, November 11 of 2020. So that sort of summarizes the complaints.
That was not a summary.
Defendant, according to his PSA, has a burglary indictable conviction from 2011 in the 3rd degree and a robbery in the 2nd degree from 2012, which is classified to be a violent offense. In addition, 2 disorderly persons offenses, one in Florida, a battery committed in 2021, also considered to be violent, as well as a disorderly persons shoplifting offense. Defendant has been incarcerated. The PSA indicates there were 2 charges, burglary and robbery.
With a lot of words.
Robbery and the 3rd degree burglary. He received a sentence for both of those charges, according to PSA, 40 years. There's one FTA that's over 2 years old and a domestic violence TRO that is active from 2020.
Yeah, but any
Involving
DUIs?
this victim, based upon the information that the state has. There is also another dismissed TRO from 2019 in Union County, but as I said, there is an active TRO. So based on the above, Your Honor, the nature and circumstances of these 4 separate incidents show a continued pattern of criminal behavior based upon the allegations made by the victim in each separate complaint. I would submit, the state would submit that the weight of the evidence is strong based upon the statements made by the victim, some of which have been provided in discovery. This has been occurring over a period of time. As indicated, defendant was in jail for a period of time. Maybe that predates these offenses.
Judge,
I don't
stop
know exactly why.
All right, guys, I've had enough.
How defendant
It's
was
time for her to
apprehended.
talk.
Recent is a risk of pending charges for all
these arguments. Mr.
For anybody who needs to hear the rest of that, I'll put it on my Patreon. Go watch it on my Patreon. It's free. You don't pay any money. I'll put a link up in a second. Okay. Now it's her turn.
Marcus, I recognize that your role in all of this is to be where you are right now making these arguments. I don't know if you're in a position to explain to the court why it is that 4 years after the fact this matter hasn't been presented to a grand jury. And do we have any evidence at all that the defendant has attempted to contact the victim in any way in the last 4 years?
They're very good questions, Your Honor. And you give me 1 second, I will attempt to shed further information. I can't answer the question in terms of the indictment. I don't have that answer for Your Honor. I don't know why an indictment has not been issued at this point in time. I could, only speculate and say perhaps, I don't know if it's even a good answer. They were waiting for the defendant to be arrested. I don't know. So maybe that's not a good answer to Your Honor's question. But as far as any recent encounters between the defendant and the victim, I am just attempting to look up one other thing as we speak, Your Honor.
Yeah, I don't know if you have victim witness advocates that have remained in touch with the victim in this matter. They may be able to shed some light.
Yes,
I guess. And and I realize none of this is really your role in this. It's not personal to you. Just when I'm trying to assess his dangerousness, I'm trying to determine whether or not. So was he extradited from Florida? Do you know?
I don't know, Your Honor. I don't know if that's the case. If I did, I would certainly answer Your Honor's question.
Of course, of course.
I did examine the CCH, and I honestly can't tell. And I know that oftentimes Your Honor is able to glean that information that I don't always get the opportunity to recite to the court.
Okay.
I don't know. I don't know the answer to that question.
All right. Thank you. Ms. Bowden.
Thank you, Your
You
Honor.
were here
On behalf of
before.
Mr. Dawson, we would
I saw
respectfully
you
ask
here
the court to
before.
release Mr. Dawson on a level of monitoring. Your Honor, he does have strong ties to the community in New Jersey. He's lived here for 27 years. He's a U.S. citizen. He does currently reside in Florida, Your Honor, but he does have an address to reside at here with his brother. He would be residing in East Orange. I do mention the Florida address just because if maybe Your Honor would prefer for Mr. Dawson to return to Florida. I'm not sure where the alleged victim lives, as that information is redacted on the police reports, but if she does reside here in New Jersey, maybe it would be preferable for him not to reside in the state. So he does have an opportunity to reside in the state while these charges pend, but he also has an opportunity to return to another state as well. And
Do you know
his whole
the
family-
do you know the circumstances of how he came to be in custody?
I believe Mr. Dawson represented to me that I guess he made contact with a police officer and there was some kind of warrant. He is nodding his head right now, but I don't have the specifics.
I'm sorry. So it's your understanding that he surrendered to the police here in
No,
New Jersey?
not a surrender, Your Honor. I believe, I don't have the specifics, Your Honor. I don't want to make a false representation.
Okay.
But again, he does have strong contacts here in New Jersey. His whole family resides here. He also is gainfully employed. He works at Amusement of America, and he works there 7 days a week. In terms of his history and characteristics, his PSA is recommending his release on PML3 as well as home detention, I believe. He's not currently on a level of monitoring, so he hasn't had the recent opportunity to prove that he can abide by release conditions. His criminal history is relatively minor, Your Honor. He only has 2 prior indictables, and both occurred over a decade ago.
Well, robbery in the second degree, you believe is not serious?
Your Honor, I'm saying minor in terms of the amount of convictions. He only has 2.
Oh, okay.
My apologies about that. And his most recent conviction is what I believe to be a disorderly persons offense from Florida. So I would say that is a pretty minor offense.
He also how about all of the assault charges that he has in Pennsylvania or in Florida?
Your Honor, I'm only seeing 1 battery offense in Florida. Am I missing something?
Let's see.
The judge is not going to let her finish a sentence for the rest of it. He just keeps arguing with her. And it's lovely because we see these defenders that are trying.
So I see
hard,
that he has the
but
conviction for battery on 9/19 of 22. And then it looks like he has a failure to appear felony 3rd degree for battery on the elderly of 4/14 of 22. Is that the same offense?
My apologies, Your Honor. I am reviewing that now. I was initially just looking at his PSA. I'm not sure is there a disposition listed here? I see filed. I'm not sure.
Yeah, that's what I'm looking for. And maybe it's explained later that he was rearrested on the same charge. 4/29 of 21, 4/14 of 22. Yes, I'm not sure. So I'm looking at that and thinking that it is 2 allegations, but it may be the same, just amended.
Okay, and I'm sorry, Your Honor, I don't have any additional insight on that.
Nonetheless, that is disconcerting that while these 4 charges, including a 2nd degree Graves Act offense involving a handgun, while these allegations are all pending, that he's now living in Florida where he's assaulting somebody over the age of 65 years of age, that results in his guilt and conviction in 2022. So it seems to me that not only does he have a robbery from a decade ago, burglary from a decade ago, he also has a battery conviction from 2022. So
I do understand your concern, Your Honor, but
I don't agree with your characterization that this is a minor record. I think this is a record that demonstrates a ongoing course of criminal activity that spans more than a decade, including violent crimes.
Well, I do understand your position, Your Honor, but again, if this.
Also, I would note that he has 1 VOP and 2 parole violations. So he's been non-compliant with his sentences previously. I'm sorry, I interrupt. Go ahead. I think I'm.
The full video with the prosecutor talkie is on Patreon then, guys. It's ready.
I'm taking issue with your characterization of his history.
I understand your position, Your Honor, but again, if the battery is listed as a disorderly persons offense, I'm not sure about the way Florida categorizes these instances, but on the PSA, it looks like it is a disorderly persons offense. So that wouldn't be considered a crime. And again, it just wouldn't be considered the most severe offense, Your Honor. So that was my position regarding the battery. And again, these indictables are quite old and quite dated. So there has been a significant period of time where Mr. Dawson has been a law-abiding citizen. So I would ask the court to recognize that, or at least take it into account, Your Honor.
Do you have a custodian to present today?
That's the judge.
I don't, Your Honor. I think I would echo Ms. Cox's opinion about custodians. Mr. Dawson is a grown man, but if the court would need a custodian present, I would ask for an adjournment. But if Your Honor would allow me to, I would like to finish the rest of my arguments, Your Honor.
Go ahead.
Don't do it.
Well, Your Honor, I think kind of the most important point here is that these offenses occurred 4 to 5 years ago. Mr. Dawson has been released. He's been in the community, so he has
and committing new crimes for which he's been convicted in Florida. So I understand that he left the state of New Jersey sometime after the allegations here in 2020, but in 2021, less than a year after he's alleged to have committed these offenses, he's committing a battery in Florida, which results in his conviction.
Well,
so I mean, I understand your role here, Ms. Bowden, but I am concerned that you've now misstated what the PSA indicates a number of times. So he's not lived a law-abiding life since these offenses. He's been convicted of assaultive behavior in Florida since the alleged commission here. And his history is that he committed a second-degree robbery, which resulted in a prison term, and he then violated the terms of his parole and got a parole violation. Previously, he was on probation, and he violated the conditions of his probation, hardly evidencing a significant period of law-abiding behavior. The recommendation here is that he be released on level 3+ home detention. And then you want to tell me that you consider Ms. Cox's argument that grown men don't need to have a babysitter. And I would say, I beg to differ. He's charged in this circumstance with pointing a gun at a girlfriend and threatening to kill her. That's the charge here, along with 10 other charges that demonstrate a course of conduct that occurred over the course of almost a year. And I recognize it's 4 years old, but he's not been law-abiding since then. He absconds down to Florida, where he commits new crime there. So give me something that I can rest on that has some substance other than characterizing things as being slight and de minimis and not really very serious, and it was only a battery.
Your Honor, I do understand your position. What I was trying to argue is that he's been released in the community and there's no new allegations regarding this alleged victim.
No, but he's beating up somebody else in Florida. He's convicted of that. That's not just an allegation.
Judge, leave
it's
her
a conviction.
Alone. Let her do her job.
I think what we're here for is about this specific instance, Your Honor, and this specific victim.
I need to consider whether or not his release is a danger to this specific victim or to the community. And in my mind, that means Americans or anyone, even people that aren't here lawfully, anyone that's residing in this country needs to know that Judge Parenti is considering their welfare when making decisions about whether to release somebody. And your client has demonstrated that he's capable of robbery and battery, and that he's not very compliant with the terms of his release when he was on parole or on probation. So I recognize that these cases are very old, and I am giving that great weight in reaching my decision here. But again, I need some help from the defense side on this, and telling me that he doesn't need a babysitter seems to miss the point. The PSA says 3+ home detention. So I would need to know that there's a responsible person in the community that sits before me under oath and promises that if he's not complying with the strict terms of his home detention, that they will immediately notify the court so that law enforcement can begin the process of trying to find him again to rearrest him.
That's understood, Your Honor. I would just ask for a brief one-day adjournment to reach out to custodian, Your Honor.
I will grant that.
Thank you.
Thank you. Mr. Dawson, your matter is being adjourned for one day in the hope that we can find somebody in New Jersey that will take responsibility to supervise you should I release you. So your matter is now concluded, and we'll see you tomorrow.
Mr. Dawson?
No, don't do it.
Mr. Dawson, please don't say anything on the record.
Please.
Anything you say can be used against you. I'll see you tomorrow, okay? And we'll talk then.
Normally, I would strongly encourage them to talk about their case, normally. But I think this judge might explode all over that public defender if he does. So this time, no. Okay, guys, the clip that broke my stream today, the clip that broke my stream is about to begin. And, you know, this crap better be good, Mr. Fleischer, because your clip almost broke my stream today. I'm looking for it, guys. Give me just it's right here. Now I have to rename it so you don't see what it's called. No. I'm a professional. Here we go. Friday Fleischer.
Reporting Reagan?
Yes, sir.
Is it Reagan or Reagan?
Reagan.
And Donald, I didn't get that part. I didn't get that part when it was me too. I just didn't get that part because I don't want anybody to get in trouble. I just don't want to be the person that got someone in trouble. I couldn't. But we all know, Donald. We all heard it. We all saw it.
Mr. Reagan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you. So, okay.
Thank you, Your Honor. On May 30th, 2024, officers were dispatched to an address regarding service call.
He is dressed.
And that earlier
That's
that day,
so
he told
nice.
the defendant that he was going to be evicted after 30 days notice. Defendant initially refused to leave, became verbally hostile with the complainant. Defendant eventually began to gather his things. The complainant stated that he was standing in the living room with the witness when the defendant intentionally and knowingly approached the complainant witness and struck him with his shoulder, causing him pain. The defendant also stepped on the complainant witness's toes. Defendant repeated this action several times. Defendant was verbally threatening and insulting during this. The complaining witness pushed the defendant away. The defendant then approached the complaining witness in a fighting stance and hit the complainant in the face with a fist about 10 times and pushed the complainant against a center island corner in the kitchen. The complainant fled the scene. Officers observed dark red laceration on the complainant's inner forearm, a bleeding abrasion to his knee, and a red abrasion to his right shin. 4 parallel
He's very
abrasions on the
confused.
complainant's
Look at him.
left side. Defendant was identified by the Texas driver's license.
Can you look to see if he has any prior criminal history, please?
Sure. I don't see any cases.
Anywhere, anyone else?
It's loading, Your Honor.
Some people saw it.
No, Your Honor.
Okay.
Mr. Reagan, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons.
Sir.
You got out of jail because you got a free bond. You will not get another one. If you pick up a new case, you violate these conditions, you will go to jail. No more PR bonds for you. You understand? Okay. What do you do for a living, sir?
I am a videographer and I use my drone for realtors and contractors, but it's at halt due to the landlord having my drone in his room at the moment.
Okay. Are you able to get it?
No, he has it. I can't contact him.
Well, that doesn't, you can try to use someone else to get your property back. That's what I would do.
He's claiming that he wants to keep it, so I don't know.
Well, then that's another issue in and of itself. I mean,
Right, yes, sir.
If you can somehow prove ownership, perhaps you can go hire a deputy to try to get it back for you or family members or whatnot.
For purchase, you mean?
Correct. You know, there are certain actions you can take to try to get property when someone's withholding it for you. I would counsel you to don't take matters into your own hands. You need to hire a lawyer, and the lawyer can help you get your property back for you.
And my mother can come get it, like you said?
Well, I don't know. I would first talk to a lawyer to see what you can and can't do. Don't take matters into your own hands at this point, because I just don't want to have to put you in jail because there's a misunderstanding.
I don't want to go.
Right. So, so do you have an income or no?
At the moment, no. That is my income.
When is the last time you earned?
What? That's crazy. I would cry. I would be in tears the whole time. This isn't fair. You didn't give me enough time to prepare. I don't know what to say. That's crazy. I need 2 weeks apparently to put one video together. Even when I take 2 days off so that I can catch up and get a stream together, it falls apart.
Like the beginning of May. My mother.
Your mother's here with you now?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay.
Yes, sir.
We'll give you an application. I can have you speak to a lawyer today. But like I said, don't take matters into your own hands. For now, we'll have you go to Victoria Sign and Reset. I will have you then take a seat in the jury box till we get your bond conditions. We'll have you sign it. And then after that, we'll have you talk to the lawyer.
Yes, sure.
Okay?
Thank you.
Please. So would you mind filing no contact and no witness, please? And then going back to the location.
And thank you for dressing up.
Donald Westerdale.
I didn't think I did. I didn't think I did.
Going backwards, man.
Page 16, Rose.
Hi, Victoria. That was an accident. I thought I passed it. I really did.
Good morning, ma'am. You are Zoe Rose. Miss Rose, you're charged with prostitution. Your face.
Victoria, that was freaking awesome. Victoria, that was so awesome.
Facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you.
Yeah, sure. On June 8th, 2024, officers were operating a sting at the Hilton Hotel. They were contacting women on ads from websites known to solicit prostitution in an attempt to get them to come up to the bedroom. The defendant arrived at the hotel room and she agreed to straight sex free.
Miss Rose, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to engage in this like behavior. Do you understand?
Yes, Your Honor.
If I find that you do this again, I will put you in jail. You will not get any more PR bonds. I took someone into custody now.
So,
Right, because she did it again. I'm not asking for much. Just don't engage in this behavior. That's all.
yes, Your Honor.
You need a lawyer, man.
Yes, I do.
Okay. Let me see if I have an application on file. Okay, I need you to fill out an application for me and then I'll have you speak to a lawyer today.
Okay, thank you.
I'll have you also go to Victoria Sign and Reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then we'll have you speak to a lawyer today. Okay, yes, ma'am.
I love the color of your jacket.
Thank you. So can you file?
No contact with the Hilltown family?
Well, I don't know about that, but I was gonna say just no prostitution. You know,
I mean,
if you want to do that, I'm okay with it, really.
just, it's broad, and so that's why.
They're gonna do it, they're gonna do it wherever they want to do it, right? That's why, for me, the most important part. If you want to, damn, okay with it, really.
I don't think my only issue, so the reason why I do that is just because I don't know off the top of that if
I did
she was
too.
issued a formal trespass notice, and so to effectuate a forbidden entry, I either have to have notice from the court or notice from the location. And because I'm not able to draw it from the complainant immediately, and obviously I could brief the court, that's fine.
Okay, so just that and no prosecution. Please. Okay, you ready?
Yes, next one, Judge, page 22, Williams, come on up.
Is it Gerald or Canadian?
I had
Which
1
one
hour
is this?
streams.
Gerald. Really? Gerald? All right, Mr. Williams, you were charged with interference with the emergency request for assistance. You're facing up to a year in jail and or a $4,000 fine. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. You cannot afford a lawyer. A lawyer will be appointed to represent you, sir.
On June 8, 2024, officers were dispatched to assault in progress. On arrival, the now defendant was located in the resident's front door walkway with a verbal altercation with the complainant who was inside. The defendant advised that his vehicle broke down. He had to walk home, became irate at complainant for not picking him up. Complainant drove with a cousin to pick him up, but nothing physical happened. However, the defendant was loud and aggressive and was in her face shouting when the complainant attempted to call 911 with her phone in her left hand. And as she was dialing, the defendant grabbed her left arm and threw her phone in her car and pulled her away, making her inaccessible to the phone. She had a scratch on her left arm from pulling away from the defendant, but I'm presuming she didn't say she felt pain, which is why the interference was charged.
So that's why they didn't file the assault.
Yes, Judge. I'm presuming, but I'll double check. It didn't say in the summary. Pulling away from, she didn't want to, no, she didn't want to press charges, so that's why the interference was filed.
And Mr. Williams, I'm going to find that there's probable cause to go forward with your case. Are you on probation or parole at this time?
That's it.
Okay. What do you do for a living, sir?
I'm in between jobs right now.
Why?
I was working for a refinery, but
can.
they own it out, so it's like a turnaround job.
When was the last time you had a job?
Like last month.
Okay, it's time for you to get a job.
Yeah, well, I got a project coming up. It'll be like next month on the 8th. So then I start that work.
Okay. We're going to reset your case to give you time to hire a lawyer. Okay. I'm ordering you now as a condition. Do you want no contact with this person?
I don't think she stated, let me double check if she actually stated that she didn't want to. I don't see a record call on it. If I could have just 30 seconds, I'll
Sure, take your time.
I always give men 30 seconds.
Judge, that's gonna be state's bond condition?
States, correct.
It doesn't say anything about wanting to, which is just that she was scared of him yelling, and she completed a blue form, but that was it. Doesn't say.
So what do you think, yay or nay?
This one?
You know what, I'm gonna do it regardless. You've got an open criminal case. I don't want there to be any bad blood, especially with it open. So don't have any contact with this person and don't be in possession of weapons. You understand, sir? If I find that you violate these conditions, I will put you in jail. You will not get any more PR bonds. I'm not asking for much, sir. So like I said, we're gonna reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, I'm gonna have you take a seat in the jury box. So we'll get your bond conditions, we'll have you sign it, and then you'll be free to go, sir.
That's it.
That's fine. Go ahead and sign for your.
Other condition on Zoe Rose. I'm doing the one on Williams right now.
All right, Judge, page 25 and 26, Wood.
I don't know what you're talking about, legal.
You now stand charged with 2 more counts of assault, Mr. Woods.
This is the guy that locked
You're
my
going to do probable
export up.
cause. You
This
have the right
guy.
to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. You cannot afford a lawyer. A lawyer will be appointed to represent you, sir.
On June 8, 2024, officers who dispatched to the Altitude Trampoline Park in reference to a disturbance. Officers met with the complainant, stating that she set up a birthday party for a 6-year-old child and invited the now defendant, who is her ex-boyfriend and child's father. They got into a verbal argument and the defendant grabbed the child and tried to exit the facility with the child, while the child was kicking and screaming to be let go. The complainant was trying to get back custody of the child, while the second complainant was also trying to assist. The defendant's girlfriend was also telling the defendant to let go of the child, but he wouldn't.
At a birthday party.
While the complainants were trying to stop the defendant from leaving, the defendant pushed the complainants into the front doors of the facility, causing the complainants to go through the door and cause pain. Officers
They went through the door?
Into the front doors of the facility, causing the complainants to go through the door and cause pain. And officers found that this now defendant had a protective order against his current girlfriend that he was with, prohibiting any contact, and that's the charge for the VPO, but it wasn't one of the people that he pushed, which is why the VPO isn't a felony, but the other ones were just assaults. But the one for the referral was an assault of a pregnant person out of the 338, and that was filed as recently as February 2nd, 2024.
Mr. Woods, I'm sending you for a drug test right now.
One of my boxes is out getting fixed. Red hat.
Illegal drugs or unprescribed controlled medication. I'm sending you for a drug test now. I'm ordering you to stay away from all of these people. Tell me, he's got an assault of a pregnant person that's open as well.
Yes, Judge.
Is she one of the complaining witnesses in this case?
So that was the one that was also telling me to put the child down, Ms. Perry, but that one, sorry, there's
a felony court, no.
I do show a bond violation filed for these charges, so I imagine they're gonna do a motion to revoke pretty soon. It just hasn't been set yet. Oh, and there was another bond condition violation report on April 24th that was never approached, but then obviously by this time we picked up the new charge.
It's in the 338.
Well, it's in DVD, so it's going to be Damien that is, sorry for
the judge.
Okay. Judge Ramona Franklin.
Was there a protective order in place in the 338 at the time?
Initially, there was, but that was back in February of 2024. And amended conditions were set on March 15, 2024. Looks like at that point, I don't know if a new protective order was expired. It probably was filed as a violation of conditions, but I'll double check right now. It was by bond condition, so violation by conditions of bond, not the protective order.
That's hilarious. We sure did.
August, guys, please keep it down. August 23, you pick up your first assault of a family member. A young lady by the name of
Ms. Henderson. I don't want to mispronounce the first name.
Ms. Henderson. in your assault of a pregnant person. Jechaliah Perry. While both of those are open, you've now picked up 2 more assaults. Why such anger, Mr. Woods? Why such anger? Over and over and over and over again. Why such anger?
Please, please, legal, please.
Tell me. I don't want to talk about the cases. I want to know where the anger stems from. What happened to you, Mr. Woods? Baloney. Over and over. You are now
But I said,
your 4th
please.
assault. What is going on with you? Tell me. Why such anger? If you think that this is going to be easy, you are sorely mistaken, Mr. Woods. Why such anger? That's not good enough. The only way all this is going to stop is when we get to the root of what anger is and why it continues. The only way you will, Mr. Woods, the only way you will stop picking these cases up is when you look in the mirror and find out why you have such anger and why it's fair to release on everybody else. Why such anger? You can't run forever. You're going to have to face this at some point. And if you can't do it on your own, then you're going to do it with me. But I'm going to tell you now, I'm not letting you go. I'm going to keep you so close to me that you're going to think that we're now a union. Tell me, why? We will sit here until you tell me why. If you need time to think, you can go to the jury box and tell me. You can tell me in 30 minutes if you need time. Do we have more cases to deal with?
We have 3 attorneys that have to show up, yes. And yes, James is on Zoom. He's waiting to see.
Take a seat here in the jury box. I want you to think about it. Okay. Well, he's joining. What's next?
There are no more arrangements.
Okay. So I guess let's get through the jury box and get everybody out.
All right.
So who do you have a question about first? Okay. James, tell me, what's up?
Good morning, Judge. I got 3 new cases. Well, I got 4 new cases, but one of them is in custody in Fort Bend, so I guess we don't need to go over that one.
No.
I have
Hey, who's first?
Kayla Cummings.
All right, come up, Miss Cummings. All right. The gentleman you see The gentleman you see on the TV on the bottom, that's Mr. Sims. He's been appointed to represent you. Do you have a cell phone? What is your cell phone number?
713-325-39.
You get that?
Yes, Judge, I got it. Yes, I got it. 3967.
So what's going to happen now is we're going to let you go. He's going to reach out to you at any moment so you guys can talk about the case. It's your responsibility to stay in touch with him. If he comes back and he tells me he can't get a hold of you because you're ducking and dodging, I will issue a warrant.
Okay.
Okay? Stay in touch with him. Good things will happen for you. Okay? All right.
Judge, August 13th through the 15th?
August 13th to the 15th, James.
August 14th is fine.
14th?
Yeah, 14th.
Okay, I have two others, Judge.
Okay, who's next?
I've got, let me take a look. Roger Calvillo.
Calvillo. On Mr. Calvillo.
Legal fiction, the poll is in. 71% of the chat thinks that you need to wax on camera.
He does not have a high school diploma. And so we ordered him to start GED classes or to get back into high school. How old are you?
22.
You are too old to get back into high school. So you must get into some GED classes. I will reset your case for 2 weeks. You must bring back proof in 2 weeks that you have enrolled into GED classes. If you have not done so, life will not go well for you. You understand, sir?
Yes, sir.
I've also told you no weapons, no drugs, no alcohol as well. I'm going to test you. You will be tested 30 days from today. So if you smoke dope after today, weed, guess what's going to happen? Good. All right. You have a cell phone. What is your cell phone number?
346 290 2605.
Was that 290-2605?
Correct.
Okay, I'll send you a text right now.
Okay. It's your responsibility to stay in touch with Mr. Sims. If he tells me he can't get a hold of you, you know what happens.
We need to see more of that lawyer.
And for this one, you had said 2 weeks.
2 weeks. Yes.
So is July 1st good with?
How's July 1st for you, Mr. Sims?
That would be fine.
Tracy, did you do
Yes.
All right, let's say you're free to go.
Okay.
And then I have one more, Judge. Let me see. Zoe Rose.
Okay. Come on, man. Miss Rose, do you have a cell phone?
Yes, I do.
What is your cell phone?
281-300-0223.
0220?
No, 0223.
0223. Okay. You've heard, this is Mr. Sims. He will be representing you. All we need you to do is stay in touch with him and don't pick up any new cases. As long as you can
Absolutely,
abide by
we need that.
then you will be fine.
I didn't even know I
will
needed
waive your
it.
appearance. You do not have to waste your time coming to court, but just stay in touch with him.
Okay.
It tells me he can't get a hold of you.
All right, no problem. Mhm.
Thanks.
August 13th through the 15th?
We can do the 14th, like with the other one.
Okay.
Yeah, okay. man.
Thank you.
Thank you.
All right, that's all I have, Judge.
Okay, thanks, bud.
All right, thank you, Judge.
Judge, was there state's bond conditions for this one?
There was. I filed them.
Did you sign them?
Let me see. Is it? I don't see it in there.
They're in there, they're on the bottom.
Where?
Somebody's made.
Where?
She's hungry.
Ay, que jodes.
Okay, that was
Okay, I'm
really
saying-
cute. Can I rewind it real
It's okay.
quick? Hold on, guys. Sorry.
Ay, que jodes. Yeah, okay, I'm sending it.
Go ahead and say the clerk.
It's okay.
Mr. Williams, since we purchased it, you did, orders the, no, I don't, no, he said he's been a contractor.
While he's not working and doing anything and playing Xbox all day, no. If he gets a job, and I'll play it.
So, not just, so, no, you're not those. Shit.
Y'all are just rude. Y'all are rude.
Come on. Yeah.
I'm gonna give you a chance to fix it, guys.
Why is it fair that the people of Harris County get to pay for a lawyer for you when you do nothing and play Xbox all day? It's not cool. If you get a job and it pays little, I'm happy to give you a lawyer. But while you're not doing anything, it's not cool, man. No. You've already told me your portion already, okay? Start working. When you come back, I will give you a lawyer. But while you're not doing anything, I can't just ask the people of Harris County to pay for a lawyer for you when you're not doing anything.
I have a job, but I'm a contractor, so my job may go, I might get, like, I start a project July 8th. It might go for a week, it might go for 2 weeks.
Then you need to do something between now and July 8th. That's an entire month. Do you have kids?
Yeah, I have kids.
How many kids you got?
I have 4.
You have 4 kids?
Yeah,
What? Do you think kids are gonna wait a whole month to eat?
no, I'm, there's no, sir, just because I'm not working doesn't mean I don't have an income coming in. I mean, I get
What kind of income you got coming in?
But my unemployment is not gonna cover, the situation is what I'm getting at. It's not that like I'm just sitting at home and I'm just watching TV.
What did he
Not
say?
doing anything productive with myself. I am, and by me not working, every time my project ends, I have to file for unemployment. So I have income coming in,
Got it.
but it's just not enough.
That's unemployment income. You should be out there looking for a job in between the project. Because
Or
you're
a job
literally
that's
sitting at
always there.
home, doing nothing, waiting for someone to call you. You are
Like
not
I am
King
now.
Almighty that they're gonna roll a carpet
Don't
for
call
you
me
for a
fuzzy.
job, man. Especially if you have 4 kids. 4 kids need food 3 times a day. They don't need food in a month.
3 times a
I'm not
day?
looking for a
I'm
handout,
not
sir.
feeding my kids that
But
much.
you are. Call it what it is.
I understand. It's fine. I understand.
Those children need food, they need clothes, and they eat and need love.
All right, that's just rude. Do you see that? Oh no, it's gonna loop, guys. We got a loop going on. Should Victoria's raise be 10% or 15%? That's an easy question. There's only one answer. How in the world did 27% of you pick 10%? Who hurt you? Who hurt you? It's just tax dollars. It doesn't matter.
Every single day. It is extremely important. You're not working. You haven't worked for how long? You don't have another job for a month. You're collecting unemployment. How on earth is unemployment enough for 4 kids?
Take child support for me to give to my kids. I pay child support for all 4 of my kids, sir. I'm not a bum, is what I'm trying to get at. I pay child support. I take care of my kids.
How much do you pay in child support, sir?
For 4 kids, I pay $500 and something a month.
Where are they getting the money from?
Okay, once I'm working, they take money out of my check. When I don't work, my unemployment withdraw my child support. They take a portion from my unemployment and they send it to child support. So I'm taking care of my kids.
How much do you get in unemployment?
Right now, my unemployment is like $800 every 2 weeks.
So tell me, why is it that you can't find a job right now in between?
I have a job, sir. That's what I'm saying. I do turnaround work. You might not understand what I mean when I say turnaround work.
Explain it to me. I'm all
Okay,
ears.
I work for a refiner, a company that works for the refining company, right? So we get contracted for a job maybe for 3 to 6 weeks at a time, right? So once the 3 to 6 weeks up, then we have to leave there and wait on another project to come, whether it's here in Texas, Denver, Colorado, Utah, Mississippi, Louisiana, however, I travel. That's what I do for my.
There you
for my
go.
work.
He can afford
So
a
once
lawyer.
I'm working or whatever, they take the money out, send it straight to child support. Once my project over with, then I have to come home and give me a paper saying that we've been laid out for the project, right? So I have to take that paper and send it to child support, unemployment. Then unemployment will have me call in every week or so, to make a claim, that I'm still not working. So once I get back to working, then I have to cut my unemployment out and I go back to a regular scheduled program.
How much money do you make on a regular scheduled program?
As far as like if I'm on a project,
sure.
Anywhere between $2,000 to $3,000.
Lies, lies.
Why can't you make this full time?
Because I'm contracted through a company. It's not like an everyday job, so I'm contracted.
But no, I don't know.
Okay, that's why I'm explaining it to you. So once they give me a project, right, they say, okay, well, we have a project going on in Utah, Salt Lake City. Okay, so then I say, okay, well, I accept that project. So once I accept the project, then I have to pay for a plane ticket. I have to pay for all my travel expenses to get there. Then once I get there and the project starts, so like July 8th, I start a job. Boom, okay, so I might be working 2 weeks for July 8th. I might be working 3 weeks. I might be working 6 weeks. I never know because it's contracted.
I would think that it would be time for you to also get a second job for when the projects are down.
Well, right now I'm in the process of buying a food truck. That's what I'm trying to get into, buying a food truck to start my own business. That way, once I am down,
I'm attacked.
I
feel attacked.
Income coming in instead of me having
That's the point I'm trying to make. You are young.
Hi, Miss Glow.
You are capable, especially the fact that you have 4 kids. You should be working your butt off to pay for those kids. That's the rub. So I don't understand how you can sit there and just wait an entire month. I guess because you get the unemployment but you shouldn't need unemployment. You should be able to get a job so that you don't need unemployment. And I have a problem just giving a lawyer to someone who is capable of working, young, strong, and capable of doing it. Because you sit there, you are literally going to sit there and you're giving money away when you can be earning thousands of dollars while you're waiting and getting $200 a week by not working.
No,
it's
true.
Silly.
No, I'm with you 1,000% on that. I'm with you 1,000%. It's just that the fact of I work on my tweet card is what I do. And you didn't know as far as what I meant about being in the refinery. I work out for my tweet card. So it's not like I can just say, okay, well, I'm going with this company right here.
There's so many other refineries out there. There's so many other.
So the thing is, with a refinery, you're like, okay, I can't just go to the refinery with my tweet card and say, hey, I want to come apply for a job. You know what I'm saying? They don't work like that. So what they do is they take, so say this guy here, he has his own company, which the company I work for is Total Safety. Right. So what they do is they'll say, okay, well, hey, I'm Total Safety. We want y'all to get 60 guys to come out here to come to work for us, for this company. Total Safety don't work for that company. They just contracted through that company. You understand what I mean? Or it's like, so say like ExxonMobil, right? We don't work for ExxonMobil. We're contracted through ExxonMobil.
I understand what you're saying. And what I'm saying is I think that's a terrible way of doing it. Because you were literally, instead of earning $2,000 to $3,000 a week, which is what your potential is, you're earning $200 a week. That's what you're doing.
With my unemployment, right? Yes.
That's what you're doing.
Right.
So I want you to go get a full-time job. And if you do, I will give you a lawyer. That's the right. Because you're capable, you're ready, and it's not fair. I mean, the people in Harris County are literally paying for you while you wait for a job. Now we gotta give you a lawyer too? How's that fair?
I don't like the fact that, because I'd rather be working.
So do it.
I'd rather do it.
Get on it, doggone it.
And I have been trying to do that. That's what I'm trying to get to you to understand, that I have been doing that, sir. You're trying to make it seem.
Show me.
Like I'm not just.
I don't know you.
True.
I've never met you.
But you see,
You know how many people
I'm a bad guy, sir, when I'm not. I'm really doing what I don't get in trouble. No, I don't. This is not my thing. I don't come here. You know, I'm a very good citizen. You know, I have been into trouble, but as you can see, man, man, that's not my thing. I don't just normally get in trouble every day. I go to work, and that's what I do. You know,
What's your last name again?
My last name is Williams. Yeah, I have.
You don't. You really. You want me to go through your rap sheet?
What I said I have been in trouble.
I don't come here. I don't get in trouble.
When was the last time I've been here? How long ago?
9/12/23, PCS was dismissed. Assault impeding breath, 12/1/21, dismissed. Interference with duties of a public servant, 15. Another interference with the duties of a public servant, unlawful carrying of a weapon, possession of marijuana, assault of a family member, possession of marijuana, unlawful carrying of a weapon, evading detention.
And how long
So, and let me ask you this. In how many of those cases have you also had a court-appointed lawyer?
And a full-time job.
How many of those cases have you had a court-appointed lawyer?
I can't just tell you like how many times.
It's all of them. The answer is all of them.
Mr. Williams, how many times have you ever had to hire a lawyer for any of those cases?
0. Wait,
You
Judge
should
Dunn.
know.
About three times for sure.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. No.
All those cases I had to hire a lawyer for.
What I'm asking you to do is work full time.
Go work full-time.
I'm cool with
I'm
that.
not asking you to split the item. I'm not asking this. 2 things. Work for me and show me, because I'm not going to take your word for it. And stay out of trouble. That's the only 2 things I ask you to do. I'll set your case off a couple weeks. You show me that you got something, I will happily give you a lawyer. But
Biden, can you drop a link to your channel, please, 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 please? Just drop a link to your channel.
while you're not doing anything and you're getting unemployment?
Could I show you right now? Or with my email?
I know. No,
because I'm saying
you're not doing it. You're collecting unemployment now.
I'm saying what I have. I just got my offer letter as of yesterday.
I get it, but that's it. What you're not getting what I'm trying to tell you. You're not going to work for another month.
Or name it, and I'll get the link myself.
Between now and then, you need to do something. That's what I'm trying to say. Or find a better job where you're working full time every single week, making that kind of money.
I'm gonna try my best.
When you put your heart into it, you can achieve anything. That's life, my friend. Anything you want, if you put your heart into it, you can do. Really. If I was able to become a lawyer, because I'm dumb as bricks, man, I'm telling you, anybody can do it. It's just how much heart are you going to put into it? How much are you going to get up and go and keep knocking on doors until someone opens it for you? Just like people aren't going to come to you looking for stuff. You're not the Queen of England, man. You have to go out, you set the standard, you set the goal for yourself, because this guy's a lawyer. And when you put your heart
subscribe.
I'm telling you.
Go, guys.
Anything.
Go, go.
It's like,
Yeah, he's cute. Be like me and subscribe.
Where we at?
We're at Serrano, page 17.
Lancaster, Pennsylvania. Nailed it. Nailed it.
What do you take? What does he got? No, just so you can talk to him. Look at you. Yeah, man. Nice, man. Little birthday boots.
SERR. Solo que después no me mira a mí la confesión española nada más, por favor.
So,
What do you mean? I'm right down the. Hold on. Pardon?
Mr. Serrano and I had quite a bunch of meetings together. I tried to inform him that I could not transfer his case to the Midland, Odessa area where he was residing. He told me that whenever he came back into custody, that he would handle it as such. He initially wanted to go to trial, then not go to trial, then he wanted to wrap it up. And then he said, I'll let you know whenever I get to the Houston area, and it's to my surprise, he's here today. So I don't think I have an agreement with the state yet. Mr. Serrano and I had an idea of what we wanted to do, but I don't know if that even is, I don't even know what's going on right now.
so what, is there an offer in these cases now?
There's a time served offer.
Okay. Mr. Serrano, your case is now 250 days old.
250 days old? Entonces ya tiene 200 de.
It's now time to make a decision on what you want to do. They have offered you time served on both of your cases, which would basically be done with your cases and will walk out of here today. You now need to decide if that's something that you want to do. If that's not something that you want to do.
His whole campaign, oh, I should put that on the screen. Oops. His whole campaign was, starting with the PR. Start with the PR and work down from that. He wants to give people second chances. And yes, we see a lot of people come back who mess up with their bond. But you don't see the people who don't come back. So he gives bonds to a lot of people and it works for them. A lot of people, the PR bond works for them. We only see the ones who come back. So it looks like everybody who gets a PR bond is just going to screw up. But that's not true. It's not true at all. PR bonds work for a lot of people. I know, say what, I got Oregon courts for you. I'm scared to do it again, but don't worry, I'm going to.
That's okay. I will set your case for trial today. And I'm going to tell you that I will not accept any more offers after today. If you decide to set it for trial, we will go to trial. I will not take any more deals from you. You will be put to trial. And if you're found guilty, you are looking at up to 6 months on each case. I don't need you to make a decision right now in front of me. I will let you step out and back. You can talk to Matt and see if the time served offer is something that you want to do. Be done with everything today. If not, we will just set your case for trial. Easy money. So please, if you'd like to step back, let me know
My
what you'd like
mods
to do.
do have to work real hard because I'm a mess and they have to keep the ship up when I'm like drowning.
Mr. Frazier, Your Honor.
Okay. All right. Good morning, Mr. Frazier. It kills me every time I see you now, man. Just, I think that, so, you're not here alone. We've appointed Mr. Brooker. He's here to represent you as well.
Say something.
Sorry?
I know I was going to say something.
Before you do, I want you to talk to Mr. Brooker.
Yes, sir.
Because anything you say, they're going to use it against you.
It was just regarding showing up the next day.
I think probably the best thing is drug treatment. I truly think that, it's literally spiraled out of control. From the first day that I've seen you, 2 years ago to now, what do you think? The problem is that you got to want it. Until you want it yourself, it's never going to take.
I'm going to triple what I pay you.
You got to get it out of your system.
What I pay you.
If you're ready to get out of your system or not. But it starts with you, and I don't know if you're ready. Are you ready or no? Street living sucks. You do stuff you'd never think that you're going to do just to get a fix. It's a hard life, man. And the longer you go at it, the more relationships you kill, the more brain cells you kill, the more just weather, just, you know.
I think drugs.
Huh?
I think it's more than just the drugs. The drugs, I feel like, is more of a scapegoat for me. I can control it.
But isn't that how, that's the escape, right? So let's do this. You've not spoken to, Mr. Brooker, you've not spoken to Mr. Fleischer yet, have you?
Not over the last couple of days, Judge, but Mr. Fleischer and I did communicate via text on Tuesday. He shared some things with me that I'll keep confidential, and this is the first time that I've spoken to him since Tuesday. I would just ask for a setting or so I can meet with the state and see what we can resolve, Judge. I know you're willing to help him.
Yeah, I'm going to tell you now, Mr. Brooker, that I will not take any time served offers anymore. I will not.
I understand.
Unless treatment is involved. And
I understand that, Judge.
It would be the dual diagnosis, residential treatment, because I think that's what what's
facility already that I've been talking.
I don't trust it.
What do you mean?
Meaning that I want to know how are you going to
It's in the state. They're paying for it. It's still
mine is
on
better.
recovery.
Mine is better, and I'll give it to you for free. That way I know where you are. You're not out and about, where you can just get up and go because you get tired of it. I think that that's probably the best thing. But you know, if I were to let you go to this place, what do you think's going to happen? You're going to get up and leave. You can lie to me, but you can't lie to yourself, Mr. Fleischer.
The reason why is
Look, I mean, look, let's
think more so. Like, I don't want to say it out loud in front of everybody.
That's okay, and I don't want you to either. So let's do this. I'm going to have you speak to Mr. Brooker and back. Okay, but I'm telling you, I'm not comfortable to do anything unless we do some kind of treatment, inpatient treatment facility.
Yes, sir. It's an inpatient facility that I was looking into. I went through a Montrose Center, Council on Recovery. They're going to pay for it.
We'll see. I'm going to tell you now, if this is a place where you can just get up and go whenever you please, I'm not down with it. Because as much as I like you, I don't trust you. And I'm not trying to make you feel bad. It's because, Mr. Fleischer, it's because I do like you.
I don't think so.
And I want you to succeed.
I won't be back there anymore.
I can't trust you to do it on your own.
Doing it on my own. I promise. I swear I tried my best, and that's what I wanted to talk to you about. On the 12th, I tried my best. When I came here on Monday, I
He's trying to get out of jail.
I told you.
Not yet. Not yet. I want you to speak to him first.
Yes, sir.
Can you please set up a TRAS for him now so we can get it done as quick as possible, please? I want you to do this evaluation because I want to know with this evaluation, it's going to tell me which facility is the best. We have several at our disposal, but I don't know which one is particularly fit for you. I'd like to set an evaluation up. Please be honest. You're going to be.
My ex-husband's going to learn
Say it
today.
again.
I tried my best to get here on Tuesday.
It's okay.
Tried my best. I didn't want to go back to jail.
Mr. Fleischer, it was going to happen like this regardless.
I tried. I needed rest. My body needed rest. And I was tired and I overslept. And I should have told you that when I was here Monday. I had been up. I hadn't gotten enough rest. I needed to rest and I tried my best. I did.
Yeah, I believe you. I believe you. But
I just couldn't make it.
we've done this before. You and I have done this before. I know that Mr. Brooker's seen this for the first time. A lot of people out there and everywhere else, they're seeing this for the first time. But Mr. Fleischer, this is our 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. This is our 13th case together.
My dog stepped on me.
The problem is it continues to happen over and over. And I know how many tears you've shed with me. But that's it. You've already had the opportunity 12 other times to try to do this on your own. I mean, think about this, and think about this, Mr. Fleischer. This is your 13th case. And I would bet of all of them, drugs or alcohol have played an issue in each. I'm willing to bet. I don't know that for sure until I do a deeper dive, but you have been entrusted already 12 other times to try to do this on your own. Now, the only way we're going to do it is this way, because I can't trust it anymore. So I'm telling you, I will not take anything where treatment is not an option, inpatient, but we will do what's best for you. So, do you mind, which number should Mr. Brooker call?
The 99.
Do you have the number, the 99, the 3199?
No, Judge, may I have it? I got most of it.
I'm gonna chat it to you, okay?
Okay. Yes, sir.
Mr. Frazier, that way you can talk to your attorney.
Okay, and then I guess we're gonna set him up for a TRAS, so perhaps we can do like a week out so that we do it quick.
Sounds good, Judge.
Yeah, okay. Thank you, Mr. Brooker.
I'll give him a call right now. Thank you all.
Okay, thanks, buddy.
Judge, did you want that to be a clinical assessment?
A TRAS to see which treatment facility is the best. So, yeah.
What do you mean?
Yeah. Yaskina.
Oh, hey, how many times has Rio Frio punch failed to appear? Please tell me. Mr. Serrano, you were charged with 2 cases. You're charged with driving while intoxicated. You're also charged with failure to stop and give information. You were facing up to 6 months in jail and or a $2,000 fine on each of those cases. What are they working on? 3, 4 on both? Or are they dismissing one? Which one? FSGI? Okay. It looks like you've worked out an agreement. They're going to dismiss the failure to stop and give information. You were pleading guilty to the DWI. The sentence is 3 days in jail. We will give you credit for the 4 days that you've done. Understand, Mr. Serrano, this charge will go on your record. It's going to be there forever. If you were ever pulled over in a car, an officer is going to look at both of these cases. They will see that you had them. If they smell alcohol on your breath, they're going to immediately arrest you and charge you with the DWI second. What we're doing today will not happen again. From now on, you will be facing a minimum of 30 days in jail. You understand?
Yes.
I wouldn't have get into a car, even if you had 1 beer, because they're going to arrest you whether you're or not. It doesn't matter. See? I'm going to suspend your ability to drive for 90 days. Do not drive until you get a license. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never change this. You understand?
Yes.
Is this what you want to do, sir?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
How do I declare myself?
How do you plead to this offense? Guilty or not guilty?
Not guilty. Let's go to trial.
We've been dealing with this for. Do you want to plead guilty to this offense and be done with this today? Or do you want to go to trial?
Okay, I'll say I'm guilty.
All right. Are you guilty of this offense? All right, I will find you guilty. I will follow the agreement. Good luck to you, sir. Please see the clerk. Do you know that I would say, I want you to look at me. Don't look over there. Don't look up. Don't look down. 90% of the people that we have in custody are because they have no self-control. They wig out and do whatever they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Every damn murder case, every aggravated assault, discharging, no self-control. You are now on your 4th assault case. Why such anger? Why no self-control? You have now had half an hour to reflect on this. Tell me what you've come up with.
My brother died in 2021. I was on the phone. I was close to him. Like he died in my home. So ever since then, I just never really dealt with it. And the only thing I got now is my kids. And then when I get into it with my baby mamas, their first thing is to take them. And y'all say do child support, I want child support. When I call the police out on the weekends that I'm supposed to get them, they tell me really nothing they can do, court not to. So it's like it's a lose situation. So I was like, I just get angry because
if you have a court order, because every parent should have equal access to their kid. It doesn't matter what anyone says, what anyone does. If you have an actual court order that allows you to have visitation and they are not giving you visitation, the proper way is you go back to the family court, you go to the judge that issued the order and you say, Judge, I have this order and she's not complying with it. You know what the judge is going to do? That will piss off the judge so much. They will haul that person into court. They will either contempt them and put them in jail or fine them, which is just as bad. That's the proper way to handle these things. And I'm going to tell you that you, by doing that, will get back at them so much more than you digging yourself into a deeper and deeper hole by picking up these cases. I'm telling you, you're only killing yourself. Do you think that you're hurting them by doing what them? No, but by going to the court and having the order enforced, you will get back at them 10 times over. That's the way you handle these things. You reflect on it and you say, okay, how do I go forth? How do I do this to where I'm going to win? Because now you trying to take matters in your own hands, you're only killing yourself. When an officer looks you up and they see your record, what do you think they're thinking? Do you think they're going to help you, even if you're right? No. All they're going to see is someone who's got 4 assaults and a BPO. They're going to think that you have horns, man. That you're damn near the devil. You're killing yourself. Do you work? What were you doing?
I work for S&S Industries, is a manufacturer, pipe manufacturing.
You've literally killed yourself by picking up these 2 cases. And the only thing that you wanted to do was get access to your kid. That really, really sucks. How can you get this job back?
I'm suspended.
So when does the suspension end?
Call me and tell me to come in. It's just due to,
They're not gonna call you, dude. You're not the Queen of England, man.
I'm saying it's due to, attendance because I just started. So, and I had to miss days due to court because I have something. So I'm just, I mean, I can call them and see if they want me to come in, Monday.
That's a good idea. You need to work. Your kids need money. I'm gonna appoint your lawyer today, Mr. Woods. What I want from you is I want one thing from you. I want you to start doing anger management classes because I want to get to the root of the problem. And I want to see you do it. And I want proof. I'm going to give you a lawyer today. My only concern is getting to the root of the issue so this cycle of you picking up cases stops. The only way is when you confront yourself. It's the only way it's gonna happen. And I hope that by doing anger management classes, you will. I'm gonna set your case off for 1 week and I wanna know what you've done. If you have any issues, I will try to help you out. The lawyer that we give you now also has services through the MAC, which is a system that court-appointed lawyers have to try to get services. If you do nothing, I'm telling you, it's not going to go well.
We are a fan of her too. We are a big fan. Huge.
Do you understand? Okay. Can you please reach out to the NAC for Mr. Woods? And then let's set it off for a week. I want you to start doing anger management classes. Do you understand? I want you to start looking into it. Do you have access to a computer? Okay. When we leave here over this weekend, I want you to Google free anger management classes. See what you find and start signing up for it.
Carolyn, he's talking to you.
There's stuff out there. If you come back to me and you've done nothing, I promise you it's just not going to go well for you. I am now making that a condition of your bond. So if you don't do it, I will revoke your bond and I'm going to make it sky high. Do you understand? Okay. All right. Come on.
Judge, earlier you said something about single word test. Are we still doing that?
No.
Isn't her voice so sweet?
My main concern is just the anger. I just need to stop. No, it'll be the state. Yeah. Do you mind filing? No contact. Oh, let me see. Let me make sure.
The judge told him to Google anger management. That's for you, Carolyn. Go Google.
As it stands now, I don't want you to have contact with these people. Okay? With any of the people in the young ladies in both of these cases, you're not allowed to have contact with them, no weapons. And then when I give you the lawyer today, do you have a copy of the court order for custody?
The one, in this case, we don't have one, but the other ones, I do.
Get that to the lawyer so they can take a look at it and see how you can try to manage visitation. Don't do it. Don't do it on your own. Do not take matters into your own hands because it's not going to go well. This is the only time that I'm going to preach this to you. I will not do this again. If I have to put you in jail and make your bond $50,000, I'm going to do it in a heartbeat. We understand ourselves. Okay, so can you on both of them, no weapons, no contact with the complaining witness?
Sure.
And that's it. Okay, so yeah, state, they'll file it and then we'll have them sign it.
Just have it.
Okay, thanks.
I already drank it, Carolyn. I'm so sorry.
Oh, so the magistrate found no PC on that one. Mr. Woods also has a violation of a protective order or a bond condition. The magistrate found no PC. So if you file a nollie on that, are you going to get in trouble?
I would get in trouble, yes, Your Honor.
So let's hold that.
They're all
until we come back
hungry.
next week, and then we'll
Go
have
cook.
either Pavel or whoever we have to take a look at it. I don't want to do him to Logan to do something that's going to. It's not a big deal, right? Whether we reset that for a week or nothing, it's not going to, no harm, no foul. Okay, Mr. Woods, come on. Don't leave until you sign the bond condition, sir. All right.
Okay,
Whew, what a stream. What a stream. We wouldn't have had the Fleischer export kill us. It wouldn't have been a 3-hour stream. A 3-hour tour. Anger management. Carolyn, I just have a question. Oh, if you're here for videos, guys, it's over. Bye. Have a good day. Have a great Saturday. Come by and see me and get a beer. I'll be working both shifts. Carolyn, when you Google something, you can't just Google it. You also have to read what the Google says about it. Aw. Don't ever wake them. Ever. I would never. If the house is on fire, maybe. But other than that, I would never wake my kids on purpose. Ever. Because then they start, Mom, I what? Can you? Will you? Can I get? No, you can't get. I'm going to get another organ. Did you see that Oregon case? Say what? I log into Oregon for the first time and I get that knucklehead. Oh my gosh. I made a short out of it today. It was awesome. It was awesome. Oh, but Mom. Thanks, guys. I hope you have a good day. I have 8 minutes before my 8 a.m. Saturday courts open. So I need to get recording. Oh, I forgot to put my camera on. That's my bad. Fozzie, if you hear, he would be mad at me. Bye, guys. Thank you so much for coming out today. I appreciate it. Legal, go get some wax and get your camera ready. Have a wonderful day, Vibers. Carolyn, you have a wonderful day too. Go drink your wine. And I will talk to you all in a few hours, I guess. See ya. Bye, guys. Who are you? New phone. Who this? Bye, Bryden.